She's calling back. We're going to try to give her a call again, and then she just added another phone number to the 13-year-old grandson who's possibly with the daughter. Step out with this.
2412.
Veteran crisis hotline's calling in, so they have a female veteran off her medication. She's over at the safe haven. You're checking 12, we'll check that one out.
6 Rumble, 2 point start, take your shots.
Officer still stands for time? No. Offender in custody? Thanks. Anyone else close, point to the result, let me know. First number. 10-4. Calling in, so they have a female veteran off her medication. She's over at the safe haven. You're checking 12, we'll check that one out.
6 Rumble, 2 point start, take your shots.
Offender in custody? Anyone else close, point to the result, let me know. 10-5. 33.
33, supervisor, calling in, location for arrest attached.
1830.
You got a possible Sheridan and Wilson?
First number. 10-4. Miss Williamson? 47-4. I'm sorry, we're not copying your lunch location. Try that one more time, puppy. 847 Fulton. 27 Fulton, okay.
Hello. You're on mute.
Freaking StreamYard, man. I don't know. This it's been acting weird last few shows, but they must be coming out with an update soon or something. Whenever it acts buggy, they're coming out with something new. But yeah, what a whole bunch of documents, huh?
I don't know what they are. I mean, I saw something about a stipulation to extend a deadline. I don't know.
Another supplemental discovery.
Oh my God.
Something in that regards. I didn't really check. I didn't get to check them out either. I literally just saw I saw the docs that got dropped. I'm like, geez, you know, it's just crazy, Yolie. You go to the website, obviously. Isn't it crazy how many documents are for this case already, and it hasn't even got to trial?
Well, you know, it is a lot. And a lot of it is just most stipulations and orders to seal.
Yeah.
You know, there's a lot.
To seal what? It's so they wanted everything pretty much sealed up since when they pulled up to 11/22, you know.
Well, the thing is that the defense counsel wanted it sealed initially, and I remember, and both parties did, and then
just like no cameras too. Each one of them didn't want cameras either.
Yeah, it's weird.
It is. It's man, I don't know. I know you got a lot to say. I got a lot to say about those court hearings too, especially the testimonies of certain individuals, and when it came to the recollection of certain things that you think they would recollect if they're the lead investigator, or they're interested in their own accolades or achievements that they've made throughout their professional career too.
Yeah, there was some questions I thought, well, I'm not sure the procedure, you know, because I probably would have asked, well, is there anything that would help you refresh your recollection? Like any documents? And he might say, well, I do have my notes, because in reality, I don't know what the procedure is. I don't know if that was supposed to be asked or what, but yeah, I mean, it doesn't look good when they say, I don't remember. I don't know.
Even if you weren't,
I don't know.
A lot of them, even if you weren't prepared, there was some things, if you were the lead, it would already be implanted in your brain. This is not New York City where they might get confused with another victim's case or something. Oh gosh, did we do this and that or not? This was something that was out of the ordinary. None of them had ever had any experience in doing, and you would think something this huge, something this
it would stick. But you know, they've never even done warrants for Google or you know, AT&T. They've never done anything like that. This was way over their head.
Oh yeah, way over their head. That's why when Lanier was first pulling up, first on the scene, second in command when it comes to Mogador or Moscow Police Department. It's like you're second in command under Fry. You're the one that's first on the scene. Why you show up 4 hours after 911 when you literally are like a 2-minute drive away? I don't understand. I mean, hell, it only takes 10 minutes to go from one side of the city to the other. It's really not that long. When you take that long and then you're pulling up, and in your own words, you tell people, as soon as I pulled up, I could tell we couldn't handle this situation, and so I called ISP. Like that right there, they weren't, none of them. I think the reason that he said I knew that we wouldn't be able to handle the situation, not only the amount of people that were out there. You see the photos from that morning. They've been circulated from the beginning. You see everybody standing out there, sitting down. It's all over the road. They got trash everywhere. It's already cluttered. You know, when you see this, it's already cluttered. You know, as you're kind of driving through. It's just, and then you have all those people, and then when it comes to what took place inside, I'm sure they had to have known. You know, I think this might have been the reason for the delay, and it's not a reason at all. But you know, Fry was out of town, right? He was out of town on vacation. Lanier is second in command. I don't think he wanted to show up, honestly. I don't think he wanted to go there and have to be responsible for making sure this was done right.
Well, that's when you get the young, police officer or detective to, hey, you want to take charge? And they're like, yeah,
it's just the 4 hours. I've never understood that.
No, and it's hard to understand.
But to me, it's like nobody wanted to, I don't want to. No, I've never. I don't know. I don't know how. I don't know what to do. There's a bunch of young dudes that were just used to handling noise complaints and busting underage drinkers, and they're like, I don't know. I mean, what you could think about anything, like when there's something huge that happens and there needs to be a change in leadership. When it's abrupt like that, there's a lot of people that'll sit there and tell you the whole time before that happens, oh, I could do this. Oh, I could do this. And then when it comes, no, him, ask him, everybody backs off. And then there's a couple, I don't know. It just, to me, and then to show up, not even get out of your car and already know that you couldn't handle it. How many people would have to be standing out here for you to know that your police department wouldn't be able to handle the situation? Because you never stepped foot in the house yet, and all you know is it's unconscious.
And we have yet to hear exactly what the 911 call said. We have yet to hear that. But assuming it was an unconscious person, did anybody, else say anything, or like, why is it secret if it was an unconscious person? Like,
because I think okay, because we heard from the very beginning, and I'm talking within the first few weeks, I was already hearing things like the unconscious person. It was reported. Now, not that it's fact, because we won't know until trial, but there was a lot of stuff going around that DM had ran out and passed out in the parking lot. Bethany was sitting on the front step in front of the door where the parking lot is, and nobody could understand what she was saying. She was trying to talk, but it was like, it
Yeah.
nobody could understand it, and those people went inside. This is just what I'm hearing. People kept trying to go inside to figure out what happened. People were coming up, coming back out, coming up, coming back out. Then a few people were able to go up there. You hear different things. I kind of think that the person on the 911 call, there's two things, because we discovered that it will be labeled an unconscious person if somebody calls in for an OD. So if somebody calls in and says, I think my friend OD'd, that means the person that called won't get charged if there's any substances, paraphernalia, or get in trouble for their friend that they're calling for having an OD. That's one of the things. That's why they want people to call. You know what? No matter what's in the house, no matter what took place, thank you for calling in. You don't have to worry about any charges. Okay.
Yeah.
That's one thing. Another thing is because it would be redacted. Now, it makes me wonder, maybe somebody did because nobody had gone in yet. If the two are out there in the parking lot, DM's passed out, fainted, passed out, Bethany can barely talk. Somebody takes their phone. That's where you get the 911 call from the person's phone in the house, but not the roommate. So they take the phone. Shout out Blackhawk. We're going to be getting to Enon soon, bro. And shout out to him. He always has great videos on Enon, especially. But somebody takes the friend's phone, one of the roommates. The friend takes the phone, calls 911. What happened? I don't know. Let me try and go in and see. They're on the phone. They're describing what they see. And then when they come back out, I could see the operator going, does one of the roommates know who or what they look like, or da 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 da? I could see that person going to Bethany. Bethany, what did this person look like? Do you know? Did Dylan tell you what they look like? And I think a description came out on that 911 call. And I think that's one of the reasons why we've never heard it, is because it does hold some kind of evidentiary value when it comes to the trial, specifically a description. And when you think of Loxton and how from March of 2023, in his affidavit saying that Bethany has an experience to her own self that nobody else can have, and also has information to the case, specifically when it comes to Brian Kohberger, exculpatory evidence. I'm wondering if the 911 call holds the description, hey, tell me what hey, this is what she's saying they look like. And with her statement and the 911 call would hold that 5'8", or a naked individual that might be a different gender,
We don't know.
That's just what because what else? What else?
That's what you're left to speculate with, because they have it sealed, and that's what happens is we try to fill in the blanks, and it sounds like that could have happened. But this is why this whole sealing thing, I think the judge is reconsidering it, because I hope he is.
This is why it's a good thing that it is in Boise, because
right,
man, if it was up in Moscow, it's the good old boy system. At least if it's down in a big city, they're a little more progressive. They're not up in that world, like we heard from James that used to live in Moscow.
Oh, right.
They tell you how it goes, and if you don't go along with it, you know.
Yeah. That was an interesting interview.
It's really crazy to think about, especially you not only got the life of Moscow, but you got the life of Moscow while you're attending the church.
Yeah, that's a good one to watch, you guys, if you haven't watched it. It gives you some insight into the town itself.
Mm-hmm. Yeah, yeah. And really defined what his soul became, because he became a soul that wanted to just get away and go to somewhere else,
Yeah,
and
I think I cried a little bit when he was talking. It was kind of emotional.
yeah. And then, your family even,
Yeah,
uh
he was.
yeah, your family's even sucked into it too. It's yeah, it's sad, but it's an adventurous life too, if you think about it, because now he's out there traveling all these different countries and experiencing a lot of things that most people don't. Um, so with these documents, we got we already knew about the hearing transcript. We had talked about that on the last show. There's one motion to seal states exhibit S1 22nd. Oh, go ahead.
Oh, the motion to seal states exhibit S1. I don't know what S1 is.
Yeah, here, I'll click on it. Let me see here.
It does. I don't know what the exhibit is. It just talks about sealing that exhibit. Oh wait, maybe it does say.
Let's see here. Come now, the state of Idaho, by and through the Latah County prosecuting attorney, and hereby moves the court pursuant to Idaho Court Administrative Rule 32G1. Idaho Code. What is that symbol, Yolie? What is that?
Section.
What?
It's a section symbol.
Why is it? I mean,
yeah, it's a section symbol. You could also
for
put
what?
section of the code. It's a section. It's a section of 74 of code 74. So it's section 74-124. You could also put section, like Idaho Code, comma, section 74-124.
That's too hard. No, I just some of these symbols, you know what I mean? I'm just like,
yeah,
what?
It doesn't. It's lawyer stuff that really is just.
Is it Greek stuff or something? Like what?
It's just a symbol. I don't even know where it came from, but it's a symbol for section.
I feel bad. You have to learn all those symbols, Yolie.
Yeah, it's just. Oh, Motomax has a question, and I'll answer it shortly.
It's a waste of time.
He gave you a $5 super sticker.
Yeah, thank you, Motomax, for the $5 super chat. Yolie, what stood out to you the most? Oh, we're gonna get to that. Trust me.
Yeah.
We have a whole lot of stuff. And that's what I have a feeling. I don't know, Yolie. I was sitting here thinking before we were starting the show, and I'm like, I don't know if we can fit it all in one show. We might have to do 2 parts because there's
Probably,
a lot.
But
there's a lot. Yeah. Here, I just want to read these here real quick, and then we'll get into those. Let me see here if it says S1.
The supplemental response to request for discovery.
Yeah. Regarding penalty phase expert.
So here's what I find strange. If you go up a little bit to the first page.
Yeah.
So the state was requesting discovery from the defense regarding their penalty phase experts. And that's the first part of the case where they have to prove that Brian Kohberger was guilty. And so they're asking for more information. And that's interesting because you always see the defense asking the prosecution to supplement. So here they're asking the state. The state is asking the defense to supplement. So,
Whoa.
Yeah. So these types of things with experts, like expert disclosures, they're kind of like, in my experience, and I don't practice death penalty litigation, but normally you just you work it out. You know, if it doesn't meet the code, you send a letter and you say, hey, this doesn't meet the code, give me more information. And you know, you work it out. And if they don't provide the information that you need before trial, then you file a motion in limine to exclude their experts because they didn't comply with the code. That's usually how it works.
Yeah, why? They're the ones that are supposed to have all the information. Why?
Yeah,
but when it comes to their expert, they want to know.
Yeah, there's a code section that tells you what information you're supposed to give the other side.
So they're claiming that the defense didn't give them everything. Or something, right? Mm-hmm. To that expert. Penalty phase expert. So that would be when it comes to the DP, right?
Right, because the defense.
So
yeah.
So that means that, yeah, because a few hearings ago, Anne was arguing about the death penalty and how they needed to decide. What wasn't she wanting to decide or trying to get them to take it away?
Yeah.
Before trial, based off of the mental anguish that he would be going through or something.
Yeah, I didn't, I don't. Yeah. Well, there's no, I mean, there were a bunch of reasons, and one of those reasons was that it was the waiting to be executed, but that was cruel and unusual punishment. But she had to throw everything under the bus. Like she had to throw everything at the kitchen sink, meaning she had to put all of her arguments, even if they were not great arguments, she had to put them all out there.
Yeah.
And he didn't let her experts testify. They wrote declarations, meaning affidavits, her experts, on regarding the death penalty, and he didn't allow her experts to testify because he said he had the declarations, the affidavits of her experts. He said that's sufficient. Yeah.
I don't know. What do you think that move was? Is that some kind of tactical move, or is that just they really? I don't know. The judge wasn't even why are we discussing this right now,
Yeah.
So what are they wanting? Like, I don't understand it.
I didn't either, but the judge is the one who set the timeline. Well, I think this may have been Judge, the previous judge, but in any event, that was the timeline by which they were given where they had to file those motions. So I don't know. It's a little confusing.
Yeah, it is. Yeah, it is confusing. This is the 22nd supplemental request for discovery. And it just gives you a bunch of articles. And what's that thing again? Section what? Section
1. It's United States and
it's
article.
Just section.
Yeah, section.
Just section. Okay. Mm-hmm. So I know from now on.
Yeah.
Let me see here. Discovery and inspection of all materials. All right. That usually says the same thing every single time. Stipulated motion to extend deadline to file motions in limine. What the hell is that?
Oh, motions in limine.
Limine. Yeah, what is that?
So there's so you saw the motions to suppress evidence, the hearings on that we're going to talk about today. Mm-hmm. That's to suppress evidence regarding what the police did, whether or not it was intentional or negligence, that whatever they did in processing Brian Koberger for arrest or, taking him into custody, that they violated his rights in some way. So you want to suppress any evidence that they got where they violated his rights. So That's the motion to suppress. The motions in limine are to exclude evidence, but the grounds are that the evidence is either irrelevant, too prejudicial, and it's likely to confuse the jury. So, for example, I'm going to give you an example. When they broke into Brian Koberger's house the way they did, you know, they found a Glock gun. I think that's what it's called. They found a gun in his room, I think. So that gun, there's no allegations that a gun was used in the crime. So that would be something you would want to exclude, that piece of evidence, because it's irrelevant. There is no allegation in the complaint that, you know, he used a gun. It only makes him look bad.
Right.
Okay.
The optics,
and that's prejudicial, and it has a tendency to make him look like a bad guy. Like, why did he have a gun?
Yeah, automatically. Yeah.
So those motions in limine are to exclude certain pieces of evidence, not necessarily the search warrants, but just pieces of evidence that may have been gathered properly, but that have no relevance and are only going to make, you know, the person look bad.
Right. Okay. Yeah, because she also did mention, because Katrina had a great question yesterday about one of the things that Ann Taylor said, and we'll go into it here in our first part, because we're going to be doing the hearings in different parts. In the first part, she did mention something about how the CAS data could confuse the courts and the jury based off of the dates being mixed up. And when he was there, because she said he did drive in Moscow, but he didn't go to the house, and the dates were mixed up, and it could mislead the courts.
Yeah, she said he didn't go there.
Right. So it was one of those things where, and Katrina had a great question, because it was like, did she just say that he was in Moscow, that, you know, when the crime took place, when he was supposed to be actually heading in the opposite direction, going to look at the stars? And I was like, I had to listen to it, like, because she gave me the timestamp, and then I went back to that court hearing, and then I listened to it like 10 times, because the first time I heard it, I was like, holy hell. But then I'm like, hold on, she said a bunch of stuff before that, let me go back.
She refers to those, she refers to certain exhibits. One is sealed, the other one is the draft cast report, and then the other one is the final cast report, which I guess she got. And she says, you know, he was driving around, and she said he was in Moscow, but he wasn't over here. And it's unclear, because they do have, like, for example, the police stop that he had in August that hasn't been released to the public.
Yeah.
He had 3 police, or he had actually 4. So he had 1 in August, 1 in October, and then 2 on the way to Pennsylvania. So the very first one in August, that hasn't been released to the public. And so I don't know why that would ever be relevant in terms of the unalivings that happened on November 13th, because there's no stalking allegation. There's no stalking. So if they wanted to use the fact that he was there or close to the home at that time, he could have been doing anything. He could have been going to the store. He could have been, and, you know, we don't know we also don't know what he told the officer, because presumably there was a conversation in August. He could have said, oh, I was just out looking at the stars. What if he said that?
Yeah.
We don't know.
Right. Well, they did say that he went. Well, no, they didn't, because what they do say is he connected to the tower.
Right.
Not was at the house, which I think they say in public, you know, he was at the house or in the neighborhood 12 times, but really you're connecting to the tower. And I actually here I put a picture together. It's just something I threw together real quick to show people where you can be in Pullman and still be on the tower. Hold on a second. It was just let me bring that up real quick. So he literally could have went because it's Bishop Road. Okay, so um when I was there, so this is when I was there, this was the cell tower right here, the range. So over to my right is where 1122 is. This is Pullman, Washington. Okay. Um, Here, let me bring us down here. This is Pullman, Washington. Over here is 1122. So Bishop Boulevard. This is the road. And if you see right here, it's the road that you turn off on the highway. So this is the highway that takes you to Moscow. This was the road he also supposedly went down on the way to go commit the crime. Bishop Boulevard, you hang a right, and you'll see it in my PCA drive-through that I did, where I went the whole route. You'll see after I go Stadium in Nevada and do the little turnaround, because they said his camera was caught going a certain he was going a certain direction. The only direction you can be going, according to the PCA, and getting caught on a camera would be turning on Nevada and going up and then back around, because there's a camera right on that building that would give you that. It's a agonal direction that they give you in the PCA when it's really east and west road. So it's when he's turning, and that's where that camera would have got him. Now he would turn onto the highway here, and then right before you do the curve, when you're on my PCA drive, right before you turn on the highway, that curve right there, you'll see a sign right up above you. It says Bishop Boulevard. That is the road that you can turn off right here and come down here. And this is Bishop Boulevard. This part of the road right here, you will actually connect to the tower of 1122 while you're still in Pullman. And then Bishop Boulevard really, honestly, could be a go around to get to Grand Avenue, because you have less traffic. You have less traffic going this way than you do going into the middle of Pullman, because around these streets and then down through here, it does get quite busy, especially up here north where these two highways meet. It does get stop and go. So in his alibi, he did use Bishop Boulevard as a road that he went on. And again, right there, you're connecting to 1122. So yeah, it just it made me wonder when it came to that, like, was that a tactic too? Because it was a good question, and she also asked that, is that a tactic as well, when it came to mentioning that?
When she mentioned the information that he was
in the area, but not. Yeah,
I think she was just explaining to the judge that, and it wasn't, it wasn't entirely clear whether she was referring to that night or any other time that they found him that he pinged onto that cell tower. It wasn't totally clear to me, like when listening to it, but it just, what she was saying is he's never stopped at that house. He's never gone to that house is the point. But when she said he's never been over there, she's been to Moscow, but he drove it he drove in Moscow, but he wasn't over there. Yeah. And it was a little unclear as to what date she's talking about. I don't know, but in any event, she referred to the exhibits, so there's a record of, if you look at the exhibits that were sealed in the cast report and then the final cast report, you could probably understand what she's saying.
Yeah, and it is when it came to that, hell, after the 2 days that I was there and learn that you have to bring everything in, with your hands and no bags. When you're living at Steptoe Apartments, there's a reason why I said if he was going to commit this crime, he would have went down Airport Road, because two things. When you're you're living in Steptoe Apartments, you're in the northeast part, very north part of Pullman, okay? And it literally is a couple residential side streets until you get to Airport Road. And Airport Road is just this country looking road until you get to the highway right before you cross into Idaho territory. So it's not only easier to go that route, but he would have went that route too, because there's no city street cameras to catch him going there to commit the crime. When he first got there, he was applying to try and help Washington State University in their surveillance stuff. He was applying to help, Pullman, Washington, shortly before all of this took place. Pullman, Washington was having a lot of assaults taking place on its campus, okay? And so the local police didn't want to hire extra officers to surveil the campus because they didn't feel that they needed to be financially responsible for it. And so what they did is they came up with a program with the university. And what they would do is the local police would have this camera surveillance network throughout the university. The students would be doing the free intern work, so the police don't have to pay for it. The students are self-protecting themselves. And that's one of the programs that he wanted to try and help out with when he got there, was that program. So if he really was going to go commit this crime, he would already know how good these cameras are. He would already know how they run, who's watching, what shifts, all of these different things. He's not going to go through. He's going to take Airport Road. Also, when you go grocery shopping, especially, you're going to go to Moscow because it's literally the same amount of time to get over to Moscow, because right as soon as you cross the border, you could go to Walmart and go grocery shopping. There's different stores around there that you could go to, and plus you're going to have bags for your items. So I'm sure there's a lot of people that live in Pullman that go to Moscow to go shopping because you get bags with your stuff. He had to be connected to Moscow towers all the time.
Well, yeah.
I mean, everyday thing. Really.
How many other people were connecting to the towers that night?
It had to be
a white car.
Everyday thing.
Come on.
Yeah. Well, and heck, whenever we show our footage, you can always see how many white cars are in the footage as I'm driving around Pullman and Pullman and Moscow. White cars everywhere.
Geez.
7 out of 10. So here's these other ones. Let me see what these other ones are here real quick. There's a few more. Let me see. Stipulated motion. No, we did that one. Order sealing Exhibit U to defendant's 22nd supplemental request for discovery. The U, that's just a one-pager.
It's just the order.
Yeah, it's just a one-pager. And then the order sealing states exhibit titled S1, and then the order extending deadlines to file motions.
In limine. So
lemony and resetting hearing.
it's funny because some people pronounce it lemine.
Well, that's how it's spelled too.
I know.
Yeah.
It's lemony.
Lemony. It's not. That sounds like a word that you would say before you go live on the air. Lemony. Yeah, you gotta like get it out of you. All right. So let me see here. We'll get rid of those court documents. And I want to say prayers to all the families for that airplane accident, the helicopter last night. That's crazy stuff.
Terrible.
I was going to talk about it, but I don't know. There's a lot of weird, fishy stuff.
For sure.
Yeah. Okay, so let me go to this court hearing. So we're going to go to the 23rd, right?
Mm-hmm.
All right. Hold on 1 second.
Offender in custody?
Yikes, sorry about that. All right, so you got from 1 minute to 2 what do you got? 1 minute to 2 minutes and 40 seconds you have confusion. What do you mean by
I'll tell you.
You'll tell me?
Yeah.
All right. So just let it play?
Yeah.
All right. So Yolie says from 1 minute to 2:40 confusion. So I'm going to go to 1:57 seconds. Let's see here. Here we go.
For the record, the defendant is present together with counsel, Ms. Taylor and Ms. Massoff. The state is present and represented by Mr. Thompson, Mr. Nye, and Ms. Jennings. We are now going to hear argument from parties on the Frank's motions filed by the defense. That will include the Frank's hearing that was held on the IGG issue, as well as the defense's proffer as to the rest of the Frank's issues as to why the court should hold a hearing on those matters, or hold an evidentiary hearing on those matters.
Look at Ann.
Am I missing something we talked about?
Your Honor, I may have missed it, but I thought we were offering argument on suppression IGG.
I missed that. I was sick.
Let it go.
Well,
Quiet, CJ.
Suppression IGG. We can also argue that. I think it's wrapped up in the same issue. I thought we were going to Frank's next.
I did not. I apologize.
She just laughed.
Reference over here, Your Honor.
Well, do you want to argue suppression on IGG and then we can do the Franks? That's fine.
I would need 5 minutes to get my Frank's items ready.
Let's do argument on the suppression of the IGG related matters, and then we can then hear the Frank stuff. That's fine. If that's what you're prepared to argue.
Thank you.
Okay.
Okay, pause it. Okay, so the reason why I say confusion is because you have, okay, so let me just tell you, you have a motion to suppress the IGG, which is not based on a Frank's hearing. And then you have a motion to suppress the IGG based on the Frank's hearing. So you have two. The second thing is you're going to argue points where the evidence was in a sealed hearing. So you got to be careful what you say, because how do you argue in a public hearing a motion to suppress evidence that was in a closed hearing? You can't, it's like a conundrum. It's like, what are we doing? Yeah, it's kind of like, what are we doing here? Like, you want us to do what? You know,
she even giggled for a second.
Yeah, it's kind of like, what? And I would be doing the same thing. I wouldn't know how to argue. I mean,
It's
you
like when you watch somebody trip and fall and you giggle for a second because you're like
you have
uncomfortable,
to
right?
be able, you have to be able to argue the evidence. And so if they have part of it sealed, the evidence part where the people are testifying, and then you're going to go argue the law, you necessarily have to argue the evidence. And the reason why we learned bits and pieces that we didn't know before is because you have to be able to argue the facts. So it was a conundrum. It was like, what? Like, how am I supposed to do that?
I'm sorry. I've had to keep it on mute because I just can't stop laughing. Oh my gosh, I missed that. I was trying my hardest that day.
It's very, very strange.
I was still so sick that day. I was, it was weird because I remember like it being weird in the beginning. My head was so cloudy I didn't even pick up on it.
Yeah, and
That's
then the
so
judge,
funny.
the judge says, we're going to argue the Franks hearing. Okay, well, he hasn't granted the Franks hearing yet. Okay, so he misspoke, and not that that's a big deal, but people were saying, oh, he granted the Franks hearing, and there's a Franks hearing, and it's like, no, that hasn't happened yet. What he wanted. Okay, so here's the crazy thing. What he wanted was the attorneys, or Ann Taylor's group, the defense, to offer proof, meaning facts, why the Franks hearing should be had. So it's kind of like when you have a meeting about a meeting, you're having a hearing as to whether the hearing should be granted, the Franks hearing. So you necessarily have to argue information that is sealed. So how do you do that in a public setting? I don't know. I think the judge was trying to make it more open, and I think in 2020, or hindsight's always, you can always look back and think, why did I do that? Because I don't know. To me, I would have been just like Ann. I would have been like, I probably would have said something too. I probably would have said, well, Your Honor, you're putting me in a position where I have to argue facts that are sealed, and I'm doing it in this public forum. So you need to either close this hearing and allow me to make my record completely, or make the hearing that was the evidence that was closed open, so that I can openly argue.
So number one, so he did that on purpose?
No, I don't think he did.
Okay. Okay. I don't think so either.
No.
Number two,
I don't think. I think he was trying to balance the need for the public to know, and the part that's private.
Okay.
And I think he was trying to balance that. And I think, like, this is a novel case, I would say.
So with you saying that, are you saying that he probably, after these closed hearings and he's looking at information and different parts of evidence and hearing this stuff in the closed meetings, stuff that's sealed that the public don't get to see, do you think was that like something that was maybe like, yeah, maybe this should be out in the public? Because
that may be why he allowed the redacted transcript.
Because he's seeing it and he's like, something smells like a hot dog steak.
Yeah, I don't think he did it intentionally, though.
So, I don't, man, because he was like, when he said it, he's like, you could see, he's like, but the thing is she didn't say what you would have said. She actually, after that took place and she kind of giggled, she was like, well, it would take me 5 minutes to get my stuff ready. So why do you think she didn't say what you would have said and instead said, Judge, it would take me 5 minutes to get my stuff ready if that's what you want to talk about? Is she kissing his ass?
Well, I don't know, because hindsight's 2020. I'm telling you what I think I would have said, but I don't really know what I would have said if I was really there, because when you're on the spot in front of a judge, like I always tell people, I'm a different person in court. I'm not talking to everybody.
Oh, I
about
know. That's why
it.
you don't come on the show for a few days before you do your court stuff, because
Yeah.
you get in a mode where it's like,
I'm a different person. There's a
yeah,
decorum. There's, so maybe I would have just been the same way, being right then and there and knowing that the whole world was watching. You don't want to.
oh, maybe that's why she said that, is because she's like, hey, if you want this, yeah, let's do this in public.
Well, it's really strange because that's why we learn certain things that we didn't know about before, like the issue with Dylan's statement, and then we learned other things. We learned other things about the trash pull, how the FBI, oh, yeah, I know.
Yeah.
Yeah.
Hey, when Yollie's got some court stuff coming up, it's like, hey,
Yeah.
you gotta stay focused, and you gotta do your business, you gotta do your business. That's why she's so good, though.
But that was my take. That was my first take on the hearing. So that's for Motomax, who asked the question. That was my first take. I'm like, and it didn't really occur to me till afterwards, so I don't think the judge did it purposefully. I think he was trying to balance this need, for public and private, and what should be private and what should be public. And, he inherited this case with all these motions to seal and the gag order. So I don't know. I mean, it was just a very strange start to the hearing, because you could tell she was thinking what I would have been thinking.
Yeah, maybe she was. She was like, hey, let's get this out in the public. All right. So the next timestamp you have, and let me see. 23. Yeah, I got a lot to say when. Let me see here. This living document and all this other stuff. Well, you got 428 to 509, no legal support for an argument. Let me see here. 428. So we can go to 4. Come on. 420. All right. So I'll let it play there for a second. So do you want this to play out?
Yeah.
Or do you want to discuss it first? Okay.
First, let it.
So you have no legal support for argument.
Your Honor, for the purposes of the Fourth Amendment protections and Article 1, Section 17 of the Idaho Constitution, we are looking to see if somebody has a privacy interest that society is ready to support. In this case, if society is not ready to support suppression of every bit of our DNA when the government does not have a warrant and searches it, there is no privacy right left.
Do you have any cases that hold that?
I do not have any cases that hold that, nor do I have any to the contrary that say that's not the case.
So,
let me pause that.
So
she couldn't find one?
No, what she's saying, and I didn't expect her to argue this, but what she's saying is that when you leave your DNA at a crime scene, they can search it by putting it in CODIS and trying to find a match. CODIS is a national. But when they take it a step further and they send it to Othram Labs, they need a warrant to search the SNP, because they make an STR profile, and that is what is put in CODIS. But to search it further with a SNP, you need a warrant. And then the FBI took it and they further searched it, and they created a SNP that was twice as big as the original SNP. So I don't exactly know all the details of what that means, but it's a search. She's saying that Othram searched the DNA, his DNA. So there is no legal authority for that. Nothing on point. So that's the uphill battle that she's going to have. with that argument, is that there's nothing on point. She argues other cases, but there is nothing legally on point to support that. So he may find that argument not to hold water because there's no legal support. But she's making a record for it. She's making a record.
There's a first for everything. Couldn't this case be the first? So then somebody else can go, well, we're going to go back to the Koberger, Idaho case. And in this court case, I mean, because it's why. Okay, so when I go back to when Gabriela Vargas was in one of the first court hearings with Judge John Judge. Okay, way in the beginning, one of the first few court hearings. It was in the summer sometime, and Gabriela, there was 3 witnesses up there that were talking about the DNA IGG, how it works, what it is, you know. And when Gabriela Vargas was up there, and she was sitting there saying, yes, they do illegal searches with this stuff. Not only she said it happens, she said she was witness to it happening. And then that's the same time when after Bill Thompson's like, well, we have no questions, Your Honor, you know, and they sent her home, and next thing you know, knock on the door, and we got
FBI.
Right. So, I mean, how could this has to do with that when it comes to the searching in other agencies?
Look, in Maryland, they have laws about this, but in Idaho, they don't. And there's no Supreme Court law on this that would override Idaho law. So there is no authority for this type of thing. But that's right. She's making a record for appeal. So if she appeals this certain issue, it could become, a law by case law, or the legislature might get involved and try to make it like a code, a section of the Code of Criminal Procedure regarding searches of DNA.
Well, how does that not? O.J. Simpson was the first case that we know of that was a mainstream media case that used DNA. One of the first cases that was using DNA like that, right? That's why everybody was like, what is this? Huh? Whoa, ho.
Yeah, that was a direct match, though.
This is a long, yeah, but what I'm not, I don't mean the type of DNA. What I'm saying is this was in 1994 when this crime took place. We're talking 2025. How does Idaho not have anything when it comes to searching DNA when we're literally 30 freaking, how many years is it? 20, 30 years? 30 years later? And you can't tell me that DNA and IGG has not been used before in Idaho up to this date. And this is the first case that they're trying in Idaho where searching DNA has to become a I can't see that. I can't.
But that's how it is. They're behind. Like Maryland has it. And I think the trend is, the American Bar Association for attorneys, they have already instructed the states to enact laws for prosecutors or for any attorney who's dealing with that kind of thing. They want them to enact a law under the legislature, like making a law that is codified. It has a code section, as opposed to a case law. So I don't know because attorneys, like prosecutors, they have an obligation to make sure that the evidence is handled properly as well. So that's a start, but they're behind in this. They're behind, yeah.
I just don't understand it. I mean, it's not like it's 2004. This is 2024, and for DNA to be, and somebody's got to be the first. This is why there's evolution and things evolve and are supposed to get better and stronger and all these different things. So basically in Idaho, is this what you're saying? In Idaho, even though it could have been an illegal search when it comes, what we would consider in our own jurisdictions an illegal search, over in that one, she doesn't have an argument?
She may not.
Wow.
Yeah, it may fail, but this is only one
Wow.
argument. This is only one argument, and it's hard to explain because I think she is talking about the manipulation of the DNA that was found on the sheath, meaning they create a SNP. And I remember this long ago, but I'm not an expert. But she's saying, you need a search warrant. You need a search warrant to further search, DNA. And we haven't gotten to the fact that they're searching databases. so
Yeah, that you're not supposed to.
They violated their policies here. And apparently there was evidence from an FBI agent that said we looked into databases we weren't supposed to.
Yeah, that's why there's no homework, because there's no proof. That's why I said just the tip way back then.
Yep.
Just the tip. We got everything, Your Honor. We've given you everything since the beginning. All right. That was interesting when it comes to that. I didn't know that, and that's kind of sad. It really is when you would just think it would be countrywide, especially after OJ.
Yeah.
Like,
Yeah.
You would just think, I don't know. It's been so long too. All right, so we'll continue. This is 509. That's where it ended. Okay. Let me see. So you got 533 to 1502 how BK was identified. Let me see here. I will get it up. 532. Okay. Now, do you want to discuss this one before we play it, or do you want to
play it first? Yeah.
Play it first? All right. So this is how BK was identified.
See from the various affidavits in this case that there's a lot of things done that don't say how Mr. Koberger was identified. And the reason for that is because nobody wanted to talk about what happened here with the genetic genealogy. That search was done by making a profile in Othram Lab. That search did not lead anywhere. The FBI took over the search, and from there they did things that we have no idea what it is. That entire segment of this case is secret. We have been through several motions to compel to try to get information, and we've gotten very, very little information. The court should know that we learned today about policies and procedures of Othram that we have not been able to take a look at. Those have not been produced. In fact, we've been told they don't exist. We learned about investigative work that was done after Othram had done the work that they could do and before the FBI took over, that we learned about for the first time this week, not through the motion to compel process.
For the first time this week? What?
Yeah.
What?
Because she called witnesses. So all the subpoenas for witnesses to appear, it was kind of crazy because they filed them in the court, but there was no name. There was nothing. It was just a blank subpoena. So they filed a few subpoenas for people to appear at this hearing. And I suspect that one of the witnesses was the Othram person who said, okay, here's our policies and procedures, because they were requested to bring certain documents. And they're like, these are our policies and procedures. Here they are. And we never found anything when we analyzed the SNP against the databases that they're allowed to do it with.
Right.
So they said we didn't find anything. So that's what she's talking about. And in terms of a motion to compel this information, I don't know if the state has the responsibility to give them third-party information. Now, the FBI information, that's another story. They should be able to get that if the FBI is willing to give it, unless they have some excuse. But the Othram information is important because she says that she was told by the prosecution that policies and procedures didn't exist. So when she called I'm assuming she called the Othram representative, and that person testified that yes, here are our policies and procedures. And when we did the snip, we didn't have nothing became of it. So it should have stopped there.
That's weird because she was asking for their procedures in the very beginning. In one of around the same time that she was asking for the training records of 3 officers that were at the scene.
Yeah.
She was looking for 3 officers' training records, and then she was looking for the procedures according to, how they handled his DNA, because she wanted their training records too, and not only their training records, she wanted all of their reprimands that they had gotten throughout their employment or whatever, because she wanted to know if somebody did something wrong too and what kind of trouble they got into. So I don't even understand how somebody could even. This is a cold case lab. It's not the first. They didn't just open. I mean, even though it looks like it from the outside, they didn't just take over a furniture store and put up a sign and open the door. How would you not have procedures? You know what I mean? Like that would be something that I would think she would have had already and would have known about.
Well, you think, but whenever a private okay, so like let's say I've always said that, okay, so the state police and the FBI assisted in this investigation. So they step into the shoes of local law enforcement, right? That they're helping, right? Mm-hmm. And local law enforcement tells them what to do. Or within whatever their expertise is, like if it's phone records, whatever so when there's a private company that helps with the investigation, I don't know how that works. If that private company also is under the state's control, meaning that the state can get the policies and procedures and turn it over. My thought process is that it is because they were part of the investigation, right?
Well, maybe when it comes to specifically how they handled his DNA.
Yeah.
But I would have to think that Othram had press conferences somewhere and had press conferences telling investors, this is our procedures and how we do things over here, because investors want to know that before they invest in your company. So I would have to, and hello, it's a huge business. There's board of directors and everything, and investors. They know everything. So to me, there would be like some kind of public, they had to go out to the public. They had to say, this is why we're different from other people. This is how our results are better. This is how because we're going to tell you, this is the kind of, this part of this portion. This is how we
They have to have them. I mean,
right. So you would think it would be like public knowledge, not that you would go to their website and you would see their procedures, but you think it would be public knowledge of how they do this or that. Maybe not specifically to his, because they can't tell anybody, yeah, we took his DNA and put it in this and ran this many tests. That has to be.
Yeah. And the key for the Franks hearing is the fact that she was told that those policies and procedures didn't exist.
Yeah, which doesn't.
That's already proven to be false statement. or reckless, because if he just said that without inquiring of Othram, can I get your policies and procedures so I can produce this to the defense? He never asked. If he just said, no, they don't exist, it was a reckless statement, possibly, or
Well,
a lie.
He did. There was a few times where he was standing up, even specifically named Orthram, Bill Thompson, and said, we reached out to him and all we can do is wait. You know, we asked them, they said they gave us everything. I don't see how, you know, if you're Bill Thompson and the first time you call up Orthram and you say, hey, the judge is requesting that we need the procedures. Can you do me a favor? Can you get it faxed over to the office? Yeah, no problem. Bam. I don't see why Orthram would be like, no, we gave you everything. We're not handed it over. You're right. It's like he didn't, like he said he reached out, but he didn't.
So it could be something about a Franks hearing that would possibly grant a Franks hearing, because there was either like an intentional or reckless statement. But again, I don't know the ins and outs of Franks hearing. It may not have anything to do with the Franks hearing. It just may have to do with the suppression. I don't know. It's a complicated thing, you know?
Oh, yeah. Oh, yeah. All right. So we'll go ahead and keep playing. It's 6:46. And yeah, that is weird, though. How did they not have procedures? It's crazy to me. Crazy.
This was a giant secret. When we get to the FBI, we don't know who did the work. You heard that any of that information is redacted. We don't know who did the work. It's a giant secret. We know that by the time the FBI gets involved, the profile, the text file, that's a snip to use to try to identify somebody, is more than twice as big when it gets to the FBI from Othram. We don't know how. We don't have any notes. We don't know who did any of the work. We don't have any lab protocols. We don't have any quality assurances. It's not reliable.
You're not asserting that Mr. Koberger's DNA sample was uploaded into any of those databases, that his was...
They don't even have a chain of custody, is what she's saying?
More or less, she's what she's saying. The chain of custody.
No.
Well, here's the deal. The chain of custody would be somebody signing and saying, I'm sending this DNA to the FBI. And then the person receiving would say, I'm receiving, this. What she is saying here is that she doesn't know who at the FBI did the testing to come up, meaning searching the databases, to come up with the ID. Like she doesn't know who in the FBI did it, because she is saying that some of that stuff is redacted. Why it's redacted, I have no idea.
Yeah, because it's all a chain of custody within its own as well. Because there's the agency, and then it has, well, this person had control of this at this period of time on this date for this test, and then this person took over here and did this part. There's like, how do you not? And so she wasn't talking about Orthram too, because it sounded like she was.
Yeah.
And how is Orthram's chain of people working on it not known either? That's
that's what it sounds like. But without having heard what Othram's person testified to in the closed hearing, because I do think she had somebody, or at least documents, it's hard to know. But yeah, that's the issue there. Yeah.
I mean, I just don't. If it's the smoking gun,
and people
what's the problem? Why hide it?
People are going to say, and there are already people saying that this is irrelevant, doesn't matter, because they got a buccal swab of Brian Koberger's DNA, and they matched it to the knife sheath. Okay, but how they got there is the issue.
Yeah.
How did they eventually get? Why did they have to break down all the doors and everything? Just why couldn't they stop him? Take him into custody, ask him questions, and ask him for a DNA sample. Now,
Or
maybe they did. I don't know, but
or like Long Island SK, get a pizza box, get a coffee cup. You were there for multiple days. You can't tell me dude didn't go to a gas station. He didn't get something at a gas station. He didn't throw something in the garbage while he's getting gas. He didn't go to a Starbucks. He didn't go to yeah, you're right. To bust down the doors in a gated community, okay, in a gated community, 3 a.m. This is what was crazy as well, is before they even set up the SWAT operation, that when they arrested him, they had people watching him through scopes of a sniper rifle before they were even getting ready to go in and arrest him. Can you imagine if one of those individuals, and all of a sudden,
talk about scaring somebody. Talk about putting people under pressure. Talk about, well, we'll get to that, but
yeah. All right, here we go.
DNA sample was uploaded into any of those databases. That his was, like, for example, his own DNA was one that was matched from the crime scene. Not asking whether the crime scene DNA was uploaded, but whether he had, as a, for example, customer of one of these companies, uploaded his DNA.
Well, Your Honor, I don't have the JED.com file. I don't have.
You're not asserting that fact, correct?
Your Honor, I'm not sure what the court is asking me.
Well, it goes to whether or not your client has standing to complain about the searches of the databases, because as the state has posited, it wasn't his DNA that was searched. At best, it was his ancestors.
Well, Your Honor, I am not sure why we're here if the state hasn't alleged that Brian Koberger's DNA was on the knife sheet.
No, I'm not talking about the knife sheet DNA. I'm talking about what they tried to match it to.
Your Honor, I would answer it this way. The way that those databases work is looking for shared DNA. Those databases don't churn out a name and say this is your suspect. I have a
privacy interest against any of my relatives that might want to upload their DNA to one of those systems. I should be able to stop them from doing that because I share some DNA with them.
That is certainly not what I'm saying. What I am saying, Your Honor, is if somebody takes your DNA and uploads it, I think you have a privacy interest in your own DNA.
Not necessarily in, let's say my DNA is taken lawfully. What privacy interest do I have in the search of the DNA of others?
That's a loaded question.
Why is it a loaded question? Isn't it a factual question?
Well, it is, Judge, but you're assuming that the DNA was taken lawfully, and our position.
I agree that part is an assumption. In my hypothetical, I said my DNA was taken lawfully. Why would I have standing to object to the search of other people's DNA simply because I might share some genetic information with them because they are distantly related to me?
Well, Your Honor, our position is that this work was not done lawfully, that it was unlawful, that there needed to be a warrant, that this was done outside of a warrant. And I'm not asserting on behalf of anybody else in this, any relative, anybody who might have been named or not named. This is about an identification process, it needed to be a lawful process. It wasn't a lawful process. It was in violation of Mr. Koberger's rights. I don't know how he cannot.
How was it in violation of his rights?
Excuse me?
How was it in violation of his rights?
Well, Your Honor, he's been in custody.
You're saying that I understand your position, which frankly is not well supported in the law, that if hypothetically here, he went to this crime scene, committed these murders, and left DNA on a piece of evidence, that he now has the ability to object to that evidence being searched for identification purposes. There's no case that suggests that concludes that. And it seems to me to be an extreme position to take in light of the case law. And I'm trying to understand how you get there.
Well, I think Your Honor is asking me about things that I anticipated the state would argue, their abandonment theory. And I would remind the court that the Ross case said that abandonment is a knowing, intentional leaving of something, for one thing. For the other thing, I think that the court is asking me to take a position where it feels like burden shifting to me.
No, I'm trying to understand the legal argument and how this is different from example from latent fingerprints.
Well, Your Honor, I think that things like latent fingerprints and like CODIS, there's statutes about CODIS in Idaho, about what's allowed in CODIS. This is a different search. This isn't an STR search. That's what happens in CODIS. This is a different search.
So I'm going now to, I'm sorry, the constitutionality of using the DNA that was allegedly on the knife sheath. And because I understand your argument is twofold. One, your client complains that a search was done of databases of other people to determine whether or not any of them might be related to the person who left the DNA on the knife sheath. That's thing one. Thing two is an objection to the law enforcement searching the DNA by testing it and getting a profile from the knife sheath without a warrant. My question goes to that latter point, understanding the basis for that, because I can't find any case law that would support that idea, that somehow a warrant would be needed for DNA left at a crime scene.
Well, I think in our briefing, Your Honor, that we cited the court to some cases.
I did, I think, one concurring opinion in a case that held otherwise.
So pause it.
Your Honor, I was going to talk.
Okay, so
wow. That was crazy.
Yeah, so first I want to say, for anybody who thinks that the judge was rude or that he was one-sided or he was being rough or no, he wasn't. He's being a good judge, and she brought the motion, so obviously she's going to get grilled about him. So when you go to court for oral argument, that's exactly what it is. It's an argument. You're not there to talk nicely with the judge. You're not there to just say your position and the judge just nicely ask you questions. He's going to press you. He's going to challenge you. It's an argument. It's oral argument. So and he's trying to get to the bottom of our argument because there's no legal, because this is something that she is trying to get suppressed, and the way she's trying to do it is the sad fact that there is no law in Idaho that allows this specific thing to be done. So she's trying to analogize it to other cases, and we don't need to get into that because it gets all confusing. She's trying to analogize it to different things, and there's she's trying to get her point across, and the judge is grilling her down to the bottom, like what? So somebody leaves their DNA on a knife sheath. No, it's not. It's not. And the good judges are the ones that.
But there's a way you can say it with, like you could be. It's almost like he was an asshole in a nice way.
Well, no, it's not. It's not that it's a Socratic method of teaching it's a Socratic method of how things work. I know it sounds crazy, and a lot of people don't understand it, and they take it personal. They're like, "Why is he doing that to Anne?" and this and that. But if you've ever been in, it is an argument, okay? And she's arguing. But
the way that she's talking to him, she's like da 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 dee da da, and then when he's talking, and she doesn't interrupt him, things like that. That last comment right before you were like, okay, pause it. That last comment, I was like, wow, there's so many other ways to say that instead of the way you just said it.
What did he say? The last thing?
Okay, here, let me rewind it, because the way he says it, it's like, whoa, bro, who pissed in your Cheerios? Hold on. Let me go back a second.
That somehow a warrant would be needed for DNA left at a crime scene.
Well, I think
hold on. Did I 3D? It was no. Maybe it's coming up.
Our briefing, Your Honor, that we cited the court to some cases.
I did. I think one concurring opinion in a case that held otherwise.
Your Honor, I was going to talk to the court about third-party data.
Okay, so
when he's talking,
you see his face.
Yeah.
When he cut her off too.
This is why, and I'll tell you why. Because when you have an opinion by like a case law that an appeal, they rule something, and they rule it this is what it is. This is the holding of this case that blah blah blah. Then you have dissenting and concurring opinions from the other justices that heard the case, so they can add information. There could be a dissenting opinion that says, look, I was on this panel, but I disagree with this decision, but the majority agreed to it, so I'm just putting my dissent for the record. That right there is not law. Okay? A concurring opinion as well is not law, because they're concurring, but they might be concurring on a different basis than what the original panel of judges. So he's getting irritated because she is arguing. I know why he's getting irritated, because she's making a record, and he's getting irritated because he knows you're citing a concurring opinion in a case which is not law, and she's just trying to make the record. But that's why, because
but when I'm listening to them talk right here, she's talking about the illegal searches, as in the FBI doing those kind of searches, going places you're not supposed to. And to me, it sounds like he's taking it as you can search DNA that's in the trash can, which she's not arguing that.
Yeah.
Right. So to me, it's like they're saying two different things to each other right here.
But in that, you're assuming that okay, so violation of FBI policy, there's no law that says that violates the defendant's right in terms of searching IGG databases. But what it does say, it says in their policies and procedures in the FBI, it says they will not search those databases. And that's exactly what they did. So he's playing devil's advocate. Okay.
Yeah, he's talking like she's talking about Long Island serial killer. That's how he's talking to her. Yeah. Like, why can't they go get his DNA in a piece?
This is part of
she's not saying that. She's talking about the illegal searches part. We're not arguing about getting his DNA from the trash. We're talking about how they got to.
Yeah. But he's playing devil's advocate because technically it isn't illegal. And you'll hear, in other words, it sounds illegal to me. I mean, it sounds bad that they went and searched databases. That's not right. They shouldn't be violating their policies. But it has to be supported by law. And you'll hear, if you keep going, you'll hear the rest of what happens, because he does challenge the defense on that. I mean, the prosecution. He challenges the prosecution on that.
Yeah. All right, here we go. This is 1331.
And I was going to talk to the court about the Davis case that talked about something that the police lawfully had and a subsequent test, the Skinner case, when there's something that's lawfully held, but there's a subsequent test. So those are the things that I want to talk about.
Okay.
Our first point is it was an illegal search. And this is if
Search,
the
which
court's
search?
assumption.
Which search? It was illegal.
Well, first the snip at Othram, then the snip at the FBI, and then the trash pool.
You're talking about the DNA testing of the material left allegedly on the knife sheet.
I'm talking about the Idaho State Police Forensics Lab taking a piece of evidence given to them by Moscow Police Department, collected at the scene, developing a STR profile, uploading it into CODIS, and I think that's the King case. It says that's fine. I know Idaho has statutes on CODIS. Uploading it there and producing nothing. There are no results there. I'm talking about the next set of moves that are super secret, that happen when there's a portion of the DNA taken and it's searched by Othram to create a snip. And then when that doesn't produce anything, the FBI says, okay, here we go. Let's search the snip ourselves. That's what I'm talking about. Those are the problems. As far as
Judge.
asserting family
Specific DNA tests done of the sample that goes from legitimate to illegitimate?
Yes, Your Honor, I think the Davis case is on point. If the court's theory that this is a lawful piece of evidence taken from the crime scene, the sheath.
Not my theory. I'm just trying to understand your position in light of the case law and in light of the state's arguments. I'm trying to find where the gristle is in this.
She's been trying to tell him that for the last 7 minutes.
Well, she has to have a case to anchor it to. That's the problem. And so she's now talking about this Davis case. The problem, well, he finally listens to her, but I don't know where this stops, but at some point it stops. What timestamp do we have on this?
This is 1537. We're past the 1502. Okay.
So we've gone way past. This is where she talks about the cases, and he does eventually say, okay. Then he basically understands what she anchors her argument to a case is what she does. And that case is something about getting evidence lawfully, like something, and then doing something unlawful with it.
Yeah. And I know Busby can appreciate me when I say this. Maybe if Judge wasn't such a smartass, maybe he would have found the gristle a little earlier, huh?
Well, the gristle, wait. The gristle is the case. The gristle is the case. She has to anchor it to a case.
But I'm saying, if he wasn't such a smartass and thank you, Busby, and so headstrong, about being right. Well, you know what? The gristle, you could have got to the gristle a lot quicker. That's all, you get a lot farther with honey, Yolie.
No, I know, but this is a typical. This is not unusual. Okay, judges can be assholes. This is not unusual.
Well, I mean, he's seemed pretty cocky from the beginning. Let's be honest. He has, but Busby says in layman's terms, yes.
Yeah, I mean, you figure he's trying to get her to anchor it to a case. So he's being a good. His demeanor might be a little rough, but he's trying to. You need a law, okay? And I get
it. I know.
Yeah.
What I'm saying is he, the gristle he desires could have came a lot quicker.
Possibly, but
because she was trying to say that the whole time, like
he kept interrupting her. I know,
right? And she kept saying it's about after she kept bringing it up, the same thing, and she's basically saying the same thing that she said earlier. It's just now he's like, oh, you were talking about that.
Yeah, because when you talk about searches, like, it's hard to comprehend how a SNP, creating an SNP is a search. And so I think he's trying to understand that. And it took him a while, but that's what judges are, just human. They don't know anything about DNA. They don't know anything. It's like, you educate me, and he's interrupting her, and finally they get to the point. But the point, they get to the point. They get to the point.
Yeah,
So,
they if that was marriage counseling, they would tell him, sorry, you guys won't make it, because you gotta have open communication in order to grow.
well, they finally but see, the judge finally got to the point. She analogizes a case. He's going to take it. He understands what she's talking about now, and they got there. But her job is to help the judge understand. And if he's hard-headed, or if he doesn't understand, because I think in this case he just doesn't understand it because there's no law supporting it.
Right. Yeah. And he's not up to, if the Idaho ain't worried about DNA searches and how, in the court system, I'm sure he's way behind. And man, that have you ever been in that position where you've had to keep your damn calm because you're like trying to explain something to the judge and he's just not understanding, and it's like, bro, I can take you to the water, I wish I could make you drink it, like, and you have to remain like Anne was, like, like all calm and collected. Have you had to do that before? I'm sure you've had. That's got to be so hard. Oh, that's got to make your blood boil inside. No?
Well, I'm just trying to get my point across and my argument, and I've always been told, like, it's oral argument. It's like you're getting into an argument with the judge, and it sounds horrible because if it's not oral argument, you do not want to be arguing with the judge. But do you see what I'm saying? Like, if you're there for a trial, you don't want to be arguing with the judge. But oral argument is oral argument for a reason. You're arguing. You're going back and forth and back and forth and back and forth. And he's going to prod you, and he's going to play devil's advocate to see what you have to say. And then he turns around and does that to the prosecution.
Is that the next timestamp, or should we just let this part play out?
No, I think, what's the next timestamp after that?
Next timestamp is, did BK submit his DNA to a third party?
That is part of this. Okay.
Okay.
When
you want me to?
Well, when he asked her, you're not arguing that, you're not stating as a fact that your client submitted his own DNA to, like, a 23andMe to a third party. Are you arguing that as fact? And she has a hard time answering it. And the reason she does have a hard time answering it is because she doesn't know what databases they looked at. She said, I don't have the JED match. I don't know what that is.
Yeah.
But she can't, she doesn't want to disclose whether or not Brian did upload his DNA. Maybe she doesn't even know if he did or didn't. The point is that she needs to see what they did in order to see if it was a family member that was matched, like they say, or if it was his own DNA that he submitted to a DNA company. Because they could be saying that it's a family member match, but it could really be his own DNA. Because without any record of
or you, just like when we first discussed with your DNA stuff, and I was like, damn, you could put Joe Blow on the thing and kaboom, Joe Blow. So they could have literally put Brian Koberger's name, submitted it themselves. Ding, there's the frickin' match.
Right. That's why she's being so careful when he asks her, you're not alleging that, or you're not stating as fact that your client's DNA was he himself sent it to a third party and got his DNA tested for his own purposes, and she doesn't answer it.
Yeah,
she
goes
basically
around
says,
it.
well, I don't have the JED match, and I'm not sure what that is, but she doesn't have the information to be able to see what they did.
But wouldn't she have asked her client?
I don't know.
Did you upload your
Maybe,
Oh.
but if she did, if it came from her client, she doesn't want to disclose, attorney-client information.
Right. Yeah,
But
wouldn't that be part of the?
Not necessarily, because like what you said, they could have done it by them. A police officer could have done it and said he was Brian Koberger.
Yeah.
And then the knife sheath is the police officer's DNA, and they match.
Like
you said, I don't know that was done, but I think she's just being very careful. And plus, we don't know what's under seal, so I don't know how she's arguing facts that might be under seal and how she feels limited about what she's going to say. Because keep in mind, they're arguing evidence that is under seal, so she can't just come out and blurt it out. So it's a very difficult situation to be in. But when we get the transcripts, we might know more.
A bunch. We'll have 5 thes on every page, and that's it.
Maybe.
Maybe 6.
Yeah.
All right.
Well,
Do you want me to skip to the 19 or let this?
No, skip.
Skip to the 19. All right. So this is 1910. About submitting the third. Yeah, because the way she answered it, she kind of took a pause there for a second. Yeah. She had to like think how to answer it right. I was like, what? Huh? Why'd you answer it that way?
Databases that changed their rules in terms of use after a different case used IGG to solve it because people don't expect to have their DNA searched.
That was the point of my question about whether or not Mr. Koberger's DNA was in any of those databases. In other words, did he submit his DNA and said, I don't want law enforcement to look at it?
Your Honor, I don't think that that's the way the question should be looked at. I think the question should be looked at in the way that we always look at warrantless searches.
Got to be a standard.
Your Honor, we're here because the state has alleged that a single piece of evidence ties Mr. Koberger to this case. They've alleged that there's a knife sheath that has DNA that they allege matches Brian Koberger. He's now been incarcerated for 2 years, facing capital murder. I'm not sure, unless we're shifting the burden to me, what else I can say.
Well, you have a burden of showing that the items ought to be suppressed.
This is a warrantless search. There's no justification for this search.
Right. Assuming a warrant is required for this type of inquiry.
Well, Your Honor, we think it is. And we think it is based on case law, third-party doctrine case law. That's Carpenter. Thinking about cell phones, that's the Riley case. If you have a cell phone that gets taken at an arrest out of a car, a subsequent warrant to search the cell phone is required. So we think a warrant was required for these subsequent searches. And there was no warrant in this case. There's an expectation of privacy.
I struggle with, I struggle, to be frank, and where you're going to have to try to convince me, I guess, is I struggle with the idea that DNA left at a crime scene, that there's any expectation of privacy by someone who leaves DNA at a crime scene, that DNA can't be, as you say, searched without a warrant to establish identity.
Well, Your Honor, I don't think any of us can go out of our houses without leaving DNA all over the place.
Not go to a crime scene.
The question of how something gets somewhere, that's the subject of the trial. I think the Carpenter case is really instructive for the court here And that case was about, it was about third party with cell towers. And there was a concurring opinion in that case. I think that's instructive. We leave DNA everywhere. If you carry a cell phone and it uses the towers, there can be a trail of where you went.
Everywhere?
I'm sorry?
Don't we leave fingerprints everywhere?
We do leave fingerprints everywhere, but I would say, Your Honor, that things like your movements, cell towers, the contents of your cell phone, those are really personal things. That's how you carry out your business. That's how you go. You drive your car to go to the doctor, your cell phone's hitting on those towers. DNA is even more personal than that. The tests are so different than they used to be now. It can pick up all kinds of information. It takes very little DNA. DNA lives on surfaces a lot longer than fingerprints live on surfaces. So without more, they're not much of an indication of anything. There's a warrant requirement to protect people from unreasonable searches. And that's what we're asserting here. There's so much information contained in your DNA, and you can't stop from shedding that when you go out of your house. None of us can. To be able to have that searched without a warrant could put anybody in jeopardy. There's no privacy left. If that's going to be the standard, you put it in public so it can be searched. That can't be the standard. That would erode the Fourth Amendment. Our position is that there is an expectation of privacy that society is willing to accept. Our position is that there's case law that supports this. Maybe not exactly directly on point, but the court talked about one of the cases that we cited that's similar. It's out of Washington. In that case, it keyed on whether the database was a voluntary, law enforcement can search this or not. In this situation, that's not the case. You know from the exhibit you have and from the testimony that you heard that the FBI went into 2 databases that they weren't permitted to search. So if the court wants to go clear to that extreme, and the court shouldn't, the court should look at the Fourth Amendment. The court should look at expectation of privacy. The court should look at the 3 places there was a warrant required and it wasn't given. But if the court wants to go all the way down to whether or not there was a database searched where the people consented to have their DNA searched, our case is different. The FBI went into 2 other databases and searched those. There was nothing else happening until that happened. And it's instructive, I think, and important for the court to think about how secretive this all was. We are months from trial, and we are learning things about how the government identified Brian today in open court when we've asked for those things. There's a reason why there's so much secrecy. That's because there's a violation of privacy rights. That's why there's so much secrecy. Your Honor, this is an extremely important motion, and the court is going to decide whether we do have any expectation of privacy left or not. The IGG evidence in this case should absolutely be suppressed.
I suspect the state's going to raise an issue that you may need to respond to, but I'll let you respond to that if they do raise that issue.
I'll be prepared, Your Honor. Thank you.
So you can pause it. So see, at the end of the day, he finally listened to her. And that's usually how it goes. You have to go back and forth and they just give you a hard time. And you're thinking like, why is this judge this way? And then the more and more you appear in front of a judge and more you argue motions, you realize this is just how it is.
Yeah, but my gosh, you took 20 you took 20 minutes for something that could have took 2, and you're already.
But she made the record, she made.
Why didn't she say that stuff in the very beginning?
Well, that too, she could have said it in the beginning, but you know what? You can't. The whole world's watching. She knows, and she's like, imagine that must be different.
Oh yeah, the pressure.
The pressure.
What's the Carpenter case that she was referring to with the cell towers? Do you know?
I don't, but I think she said it was a Washington case. Washington State case.
Yeah, that's the only state that they're like cool with because they actually envy Washington on
So
how,
yeah.
yeah, and a lot of stuff.
So she's using another case from another state to be instructive. It's still not the law in Idaho, but she's trying to analogize to other case law in another state to help the judge understand that other states have held this, and so she's making a record. She's doing what she needs to do.
Why wouldn't this have gone if there's no way to like rule on it, so to speak, then why wouldn't it have went to the Supreme Court? So then there is the Idaho, not the United States, but the Idaho Supreme Court to then make a law.
Well, it's not time yet. I don't know if this has happened in Idaho before or not with the IGG. But if she gets rulings on this, she can either, there's two ways. One, she can do that interlocutory appeal and appeal right away to the Supreme, to the appellate courts and then to the Supreme Court, or she can wait until the case is done and then appeal all the issues, including this. And that's when it gets to the appellate court. So right now she can't do anything because
it has to go through its process. Yeah. Then they have to go back over there and then they base that ruling based off the argument and what was already decided already. Man. It seems ass backwards to me, really. You should be proactive and not reactive, I guess. You would think. We'll get into the unknown DNA. I think that might be on the next one. We're gonna do part 2 on Sunday. And so whatever we don't get through on this episode, we'll be doing the same time on Sunday night, 7:30 Central, 5:30 Pacific, right? 5:30 Pacific. So we'll be back here on Sunday doing some more of this. Okay, so about him spitting. Now the trash poll video at 31 minutes. What do you mean trash poll video?
You'll hear right now.
Okay.
You can play it.
Let me see. So 31 straight up. All right, we'll take a listen and see what it says.
Policy violation isn't sufficient. Even the Department of Justice, as powerful as they are, they don't get to rewrite the Fourth Amendment by changing this policy. Now, I do want to address the defense is they're trying to pick and choose what they believe the searches are throughout this chain. And what they're leaving out repeatedly is where this DNA started. Where did the chain start? Well, it started at a quadruple homicide, at a crime scene. There is no case law anywhere that the state could find, and the defense has not cited any to suggest that there is a reasonable expectation of privacy in DNA found at a crime scene. And I want to talk about the Davis case, Your Honor, because it actually cuts against the defense. Davis is the case where it was a very unique set of facts. There was an investigation into a shooting. An officer went to the hospital, and when he went into the victim's room, he saw a bag of clothing. He seized that clothing under the plain view exception to the warrant requirement. So the clothing wasn't abandoned. This was an exception to the warrant requirement. Later on, this individual who was a victim now becomes a suspect, and they have this DNA and they test it. And the Fourth Circuit said, no, you can't do that. You can't take it because he's a victim and then later use it against him as a suspect. That is nothing at all like what we have here. And in fact, if this court looks at the district court opinion that was affirmed by the Fourth Circuit, it expressly states nothing about this holding is indicating that the government needs to get a search warrant for crime scene DNA. That does not support their position. The Achilles heel in their entire chain argument here is that There is no case anywhere that suggests that a DNA analysis restores a reasonable expectation of privacy. So in the Davis case, no one lost their reasonable expectation of privacy. It was seized pursuant to the Plainview Doctrine. The other case that they're relying on is that recent Supreme Court decision from Arizona. They attached it to their reply. That case is similar to Davis in that the DNA was collected from someone who consented to it under a statutory framework because they had to provide 2 vials of blood so it could be tested for alcohol and drugs. Again, that case would have come out differently had the 2 vials of blood been found at a quadruple homicide. That is a pretty big factor in deciding whether or not someone has a reasonable expectation of privacy. In Idaho, while this specific issue has not been addressed by the appellate courts have told us what to look for when you're talking about a reasonable expectation of privacy. And it's things like ownership, possession, control, ability to regulate access. Mr. Koberger had none of those things with respect to the DNA on the knife sheath. We are talking about not just a crime scene, not just a murder scene. We're talking about a murder scene in a house to which he has asserted no connection whatsoever. 4 victims to which he has asserted no connection whatsoever. We're not just talking about his DNA happened to be found in, a dresser drawer or something. It was found on a knife sheath where 4 people were killed by a knife. This is as crime scene as it gets. And that's where the DNA was found. And they can't cite any case law whatsoever. And so they try and just ignore that and skip over it and say, well, let's just talk about the DNA analysis. The other problem they have, as this court questions indicated, is the analysis that was done in this case, as we heard the evidence today, is not something that revealed a bunch of private medical information. In fact, the defense's own expert, who is engaged in the same kinds of conduct as Othram in terms of developing these SNP profiles, said he had successfully developed hundreds of SNP profiles and never once learned medical information about any of those individuals. He testified that he has never even heard of a forensic investigative genetic genealogy case that was solved using medical information. And in fact, and I wrote this down when I asked him what he would need to do to learn medical information.
I don't understand. What's he even?
This may not be the right clip.
Oh,
I may have messed up on the numbers, but he's just arguing that there's no case law to support what she's trying to argue.
Well, yeah, I mean, because I was focused on what he was saying and what he's arguing back. She wasn't talking about that. It's kind of like what the judge thought in the first place when he was being a smartass. And it's like the prosecution is arguing to the judge that she shouldn't be able to argue that, but he's going off of what the judge first thought before he get. It's like, what are you arguing, bro? I don't understand what he's doing.
Yeah, he's just trying to convince the judge that the original way he was thinking about it was correct. That's and I wouldn't have clipped this, but I don't know. I may have messed up with the numbers.
Oh, you're fine. No, but it's good to discuss though, because I'm sitting here going, I don't think anybody's. Yeah, you should be able to. Because how does an officer know? Yes, we want to search these pile of clothes in this room. Of course, they're not going to know that before they go search. So yes, they should be able to say, "Hey, there's a suspicious pile of clothes. We need to, need to tag it." Of course. So that's why I'm sitting here going, he's in prejudged 25 minutes ago mode. And I don't understand it. Would you? So if you're in that, and you're in that position, would you even get up and argue? Like if you were in this position, and somebody was arguing to have this available, and there was confusion about how, just the same kind of setup, would you even get up and have an argument for for what was already discussed between the judge and the other side. And do you see what I'm saying?
Well, he gets okay. So the prosecution gets a chance to be heard, because it's her motion. So she argues first. Now he argues, and then she gets a chance to rebut his argument, and that would be that.
But what I'm saying is it's a waste of your time, isn't it? To go up there and argue something that I'm sure, when I'd be sitting there as the judge going, we just discussed this and that's not what we're talking about.
Well, look at his face.
You know what I mean? Like, so would you even no argument? Okay, move on. Or would you stand up there and argue something that's not what the argument's about?
You need to. It's about making a record. So, you don't necessarily have to argue. Just like you don't necessarily have to cross-examine somebody. Like there was a lot of witnesses they didn't cross-examine, like Gabriela Vargas, and they didn't cross-examine. So you don't have to do it, but it's customary that's what you do. You have to argue something.
Oh my gosh.
And you have to make a record.
What do they call the stenographers? What are they called?
Court reporters, yeah.
Yeah, that's gotta suck. You gotta be doing all this for a waste of time.
Well, it's a waste of time in how we see it, but on an appeal, every word is going to matter. You know what I mean? And you know what I mean? So that's the importance of the court reporter, because the court reporter is preparing the transcript, and that's what's going to be used on appeal.
So instead of when the appeal comes, instead of the prosecution, we have nothing to say. Even an argument that has nothing to do with what they're talking about is still an argument when it comes to the appeal process, and that helps. I get that. My gosh, it needs to be
streamlined.
It needs to be retooled or something. Come on, because there's already a backup, right? Is the backups getting worse after? Is it still kind of huge delays with everything, or is
everything is just so disorganized? That's all I have to say. There's a backup still. It's getting a little bit better, but everything is organized. You never know. Will you file something and then I don't know.
All right.
It's like they never got back to work. It's almost like everybody's working half staff.
Yeah.
It's just, but yeah, there was a big backup because of COVID.
Yeah. Yeah. So let me see. Do you think it's in the 30 that timestamp, the trash pull video, or do you want me to go to the 40-minute timestamp about what the state bound by what the FBI does?
Oh, okay. Yeah, go to that one, but the one that the trash pull is what I wanted to talk about is the that we learned in the hearing, and they talk about it, how the FBI talked to the trash people, the people who were picking up the trash, and instructed them to get the trash from Brian Koberger's house. And then the trash people got the trash, and then they gave it to the FBI. So I think most of us thought that the trash was just out on the street and the FBI just got it.
But it's in a gated community, so that it's not
That's the argument.
Yeah, you can't get in there without having access.
Well, that's what she's arguing. That's what the defense is arguing. And I didn't know that they had they had a third party go and get the trash. Why did they do that?
Right.
The question is, why did they do that if it was out there on the curb? And now you have a third party person who is potentially in the chain of command in the chain of custody and getting the trash. So, it just sounds very strange if it was left out on the sidewalk, I thought they just went out on the sidewalk and got it.
Yeah, that's what I thought too.
But no, we learned that they instructed the person who picks up the trash to get it and then hand it over to them.
Yeah.
And how that happened? Did it get mixed up with other trash? I mean, how did that happen? It's insane. And why did they need to do that?
Yeah, because they sat outside the gate.
Yeah, this is weird.
That's what they did. They probably sat outside the gate, found out when they get trash, and then said, "Hey, do us a favor here. Hold on a second, sir. Do us a favor. We need you to get the trash from this address and bring it back to us. Go get the trash." And then they brought it to him and left it out of the gate, because if they would have went inside the gate, would that not have been an illegal search, right?
But they did go inside the gate to arrest him.
Right. After they got the trash to link him.
Yeah.
But before that, if they tried to go in there, because they need to have access, they would have either had access probably from the owner, because I doubt a neighbor's going to be like, "Yeah, come in, go ahead." They would have to have granted access, and without that granted access, that is an illegal search. But you're right. If you're relying on the trash company, they don't know how to handle DNA. They don't know how to contain it and properly transport it and all these other things. You're right. So
that's an argument. I don't know if it will win, but it is. I think I didn't know about the whole intermediary trash person that got it. So
yeah.
I
didn't know either. I had always thought, hey, it's not illegal for them, just like it wasn't illegal for Long Island serial killer for them to go get the pizza box after he ate a pizza.
And that's what she argues, that was a misrepresentation of how they got the trash, because they didn't put that in the arrest warrant. That they just said they got trash, and it wasn't specific enough. When maybe if the magistrate would have known in the probable cause affidavit for the arrest that they used the trash person to get the trash, maybe she would have had more pause, but I don't know if it would have made a difference. But she's arguing everything under the sun, so that is one of the things she's arguing.
Well, I mean, it should be, because that guy was not trained. Get his training records too. That guy wasn't trained to handle DNA and contain it and transport it. And yeah, that's why because they couldn't go in there. Yes, public trash is public when it's on the curb, but we're not living in a gated community where you have to have special access and a code or a key to get in. And that's where the barrier is. And
that's why they had to get the trash guy to get it and take it out of the gated community. And that is the argument.
Yeah. To sit there and set it on the street, took the trash, set it on the street right outside of the gate, right at that moment, once it touched the street, because it couldn't be handed. It had to be touching the street. And I guarantee you they waited until that trash can touched the pavement for them to touch it themselves. Because if they would have touched it straight from the individual, that is, you are part of the process of getting that without, with it still not being public, because you're doing the roundabout way. So, they live in a gated community. You have to have permission, Rogue. Yeah.
So I think that she may lose on that for a number of reasons, but that's the argument, and she has to bring it because it's part of how they identified him.
Well, yeah. I mean, yeah. Because if you have to, just like everybody, like seriously, when have you ever heard of law enforcement having a trash worker transport trash for them so they can test the DNA?
Yeah,
that tells you right there. That tells you right there. Let me see here. Where we at? 4003. Okay, so We're on 40. We need to go to 4045, state bound by what FBI does.
Many defendants in other states who have, and yes, IGG was used in this case, and yes, it did point to the defendant. But the fact that that happened doesn't mean that there was a violation of the Fourth Amendment. Unless the court has any questions, you're asking to deny the motion to suppress.
If the FBI, in fact, violated the Fourth Amendment rights of Mr. Koberger, you would agree the state is burdened by that?
It's a great way of putting it, Your Honor. Yes, the state would be burdened by that. Yes.
And the reason, and people would always get on me and they'd say, no, the FBI doesn't, they're not going to turn over, they're not anything. But no, the FBI did step into the shoes of local law enforcement. So whatever they do is going to affect it, and they're bound by it. So when they're talking about statements on the search warrants, which I don't know anything about search warrants, and they have different forms, and I don't even want to go into that. But when they talk about false statements in the affidavits, they're talking about a group information that a group has, that they all have knowledge of it, so they can all put it, and sometimes they cut and paste, and but if the person who's cutting and pasting something from somebody else has reason to know that that other person is making a misstatement and they use it, does it really matter? If the original person who did it, who made the misstatement, is an FBI agent, you don't have to have another person who's Moscow PD rely on it. The FBI themselves can be held as part of the whole group. And so the FBI steps into the shoes of local law enforcement, just like the Idaho State Police. They're all doing this investigation. It happened in Moscow. Moscow asked for help. And so they come in to help. And doing that, they step into the shoes. And so he admitted it. He admitted it because it's the law and that is how it works. And he said, yes.
Yeah, because it's one. That's why, when some weird stuff goes down and if usually it's corrupt law enforcement and they know I better call in the FBI before they come looking at this case, because if I call them in first, I can keep them away from certain things. I can control what they do in the investigation that we're working on, so to speak, not necessarily control how they do it, but they can say, FBI, we don't need your help for this. And they have to say, okay. It only at only a certain point, when something like Henrietta, Oklahoma, that Jesse McFadden case, only when it gets to a certain point do those higher agencies take over, because then they say, yeah, the local didn't do this and didn't do this and didn't do this. By God, the local law enforcement left evidence all over the place in that house in Henrietta. And it was crazy what was left over, and cell phones even, and then when family got there and they seen all the stuff that they were finding, they're like, whoa, the chains that were in the wall that were covered up, all sorts of stuff, right? That the local law enforcement, we didn't know that. And that's when the OBI, Oklahoma Bureau, came in and said, no, we're going to do all this. And so, when they called in the FBI, that was their invitation, and they could say, no, we don't want you to do this, or we only want you to work on the video, trying to find the car and the DNA. That's it. And so, they are an extension of that. That is true. So, why did he have to admit that? Or it's just with him admitting it, it was one of those things where they can use later on and say, well, you've already admitted.
It removes an issue to be argued.
Interesting. Why do you think he said that?
Why do I think he said what?
Why he admitted to that? Yeah.
Because it's the law. It's the truth.
Yeah. So
He has to.
Had no way around it.
No, he had no way around it. And he, the judge was trying to find out, are you gonna lie here? Are you gonna try to wiggle your way out of here? And he didn't. Because if you're an attorney, you don't want to lose your license for trying to lie about something that you know is the law and say no and have some stupid. See, that's the thing. You have to have law behind you. And the problem with Ann Taylor's argument is there isn't anything on point. There isn't any law. So he had to go harder on her. I know it sounds terrible. I mean, he could have been nicer, but it's
like I was kind of like when I brought it up, it was like I remember being a little kid and I had to do twice as many drills and shoot twice as many shots and do twice as many exercises, and I'm like, I'm one of the best effing players. Why in the hell do I need to do all this when they can't even make a basket? They should be doing the extra stuff, and I didn't understand it. It's they try and get the best out of you using some kind of like reverse psychology type thing or something like I don't know. It's kind of a weird way to do it, I suppose. It is what it is. All right, so the 49 45 timestamp Frank's hearings and warrants.
Yeah.
And it's about a minute long. Play this one through.
Yeah.
And okay. Here we go.
Had false information in them that was intentionally placed there. There was intentional omissions of information that are material and exculpatory to Mr. Koberger, and without the false statements and with the added information in, probable cause on the warrants should not be found. Today, I'm asking you to listen to what we have to say, look at the exhibits that have been admitted, and I'll walk through those with you to talk about the 13 areas. And at the end of this hearing, we will have met the preliminary showing required in order to schedule a Frank's hearing and fully challenge this.
With the exception of the IGG, which I think we've already heard the evidence on. So
we did hear the evidence, Your Honor, and I will not repeat that evidence. I'll argue from that today.
My only point being that's not in the preliminary stage that all the other issues are on.
Okay. Well, I'll try to hit that as hard as I can.
So,
Your Honor, in this.
So here's where she's trying to clarify that. Look, I'm going to argue the Frank's the proof, the offer of proof that you want on the Frank's hearing, because it's very confusing. So there's no Frank's hearing yet. It hasn't been granted. So right now she's just giving facts that she expects to prove in the evidence portion of the Frank's hearing. But it's kind of hard because some of those facts are sealed. So she's telling him, I'm going to go through the 13 points. And then he says, well, you already talked about the IGG with the Frank's hearing earlier, so I don't want you to go into that. So it just makes it very confusing in how you're supposed to argue this. And I don't think that it's intentional, but I just think it's the complication of the materials that they're talking about. And it just makes it really hard. I mean, I put myself in her situation. I'm thinking, okay, here we go. How am I going to do this? And later on, you do hear stuff that comes out that we didn't know. And it has to come out because she has to make a record.
Yeah, it seems like, I don't know. It seems like she, with the things that she keeps saying like this, it seems like she's got, it seems like she's got a lot of rebuttals when it comes to the evidence that's going to be shown in trial. 13, not to mention a whole bunch of the other stuff that they're bringing. It why do you think that they haven't even decided or scheduled this Frank's hearing? Wasn't that supposed to be figured out the day before this?
No.
No?
That's what people get confused, and I didn't know this either because I don't do criminal law, and I'm not. I know just vague, generally about motions to suppress and motions in limine. But the Frank's hearing is based on a case, and so what he's asking her to do, she's already put in the paperwork already for the Frank's hearing, saying this is what we got, and we want to request a Frank's hearing. So on this day, he was supposed to decide whether a Frank's hearing was going to be had or not, and then schedule it in the future. But instead, he asked her
in the beginning
to give an offer of proof, meaning tell me what you expect the Frank's hearing, the evidence to be. Okay. So a lot of this Frank's evidence is sealed. So he's asking her to do it in open court. So how do you do that when the evidence is sealed? How do you give the judge facts that are sealed in an open setting? And it's a conundrum that I see, and I've never had to deal with Frank's hearings. I don't know anything about them. This is just from a layperson attorney who argues cases and motions, and I feel like it's almost like she's like having to think every little thing before like she says it. But it's impossible for things that are sealed not to seep out. And that's why you learned about the handrail, the blood on the handrail of the stairs. That's why you learned about the fact that Payne was watching on his phone the drone feed of what was going on in Pennsylvania. That's why you learned that Dylan's statement was all over the place. That at one point she said, I can't remember anything.
Yeah.
And so you learned these things because it was impossible not to, So I think the judge realized that and said, okay, well, I'm going to let the redacted transcript come out. And the redactions should only be minimal, I think, because it's impossible. I mean, you can't put somebody in a situation where they're going to argue facts that are under seal. How are you going to give an offer of proof of facts to convince the judge to give you a Frank's hearing when those particular facts are under seal? You put me in an open court, it's like having your hands tied behind your back.
Yeah, and how are you supposed to argue something that you yourself can't see because it's sealed from the prosecution, right? That too.
The defense can see.
Because there's just like she don't know who did what on the FBI, but I guarantee they do.
Well, I don't see. Here's the thing. That's.
They worked with them. Yeah. They worked with them.
But so when you have somebody saying, I don't know, as opposed to I don't remember, and this will answer, I hope Katrina's listening. This will answer Katrina's question about whether I don't remember is a tactic. Well, what's more telling is I don't know. When they say I don't know, because they should know who did certain things, especially the lead investigator, who's the person who is tasking everybody to do things within their specialty, right? So when they say I don't recall, it's almost like you can't recall every single thing you did in an investigation. You can't.
I didn't recall yesterday, but I can recall today, kind of thing.
Yes, you can't. And so
yeah, Moto Man, thank you for the $5 super chat. And you don't have to do that to ask a question. He says, by asking her to divulge her case in advance of this Frank's hearing, is it not giving the prosecutor extra time and information to fight back with? That's a good question, too.
Well, yeah, it is.
It does. It does.
All of the information that she gave was was
Thank
in
you,
the
Mona.
paperwork. Okay, so all of the information that she gave was in her in the paperwork. So that should, maybe there should be an oral argument about why or why not there should be a Frank's hearing. But if that was going to be the case, then close the hearing so that she can at least speak freely.
Well, what did they talk about the day before this court hearing then? Because what shouldn't everything have already been put out the day before this court hearing? And that's it. You talked about it. We moved on. Now we opened it up. Why are we?
Because in the Frank's hearing, you're going to have a whole set of other witnesses come in.
Yeah.
But
they already talked about it. They already talked about it the day before it went to public mode.
We don't know that though. See, those were for motions to suppress, and so all of those people.
Oh, I thought they discussed that.
It was for the motions to suppress, the IGG and maybe a couple of other people. So they haven't presented the evidence yet, like the witnesses that are going to talk in the Frank's hearing. Okay. That's what he's asking her. Tell me what these witnesses are going to say, or give me an offer of proof why I should grant the Frank's hearing. So they haven't gotten there yet. And so he's asking her to give an offer of proof. Convince me why I should have the Frank's hearing. And some of those facts may have already been discussed, but some of them may not have. And so when there's a Frank's hearing, they're going to have witnesses come, a whole new set of witnesses.
Mm-hmm.
And then I don't know if that's going to be closed or open. And then she's going to have to argue why the Frank's motion should be granted. Why the actual Frank's motion should be granted.
Well,
not whether she gets a hearing, but whether it's granted, because she already got the hearing.
Well, why is he asking her this question in a public, on a public feed? Why wouldn't he say, wait till the end, or, hey, camera people, shut it down and mute it for a second, and then ask her? Why is he even asking her about it if this stuff's under seal like it is?
Well, I would love to talk to a criminal defense attorney about it, because this is just my opinion and arguing motions. But when it comes to Frank's hearings, I've never done one. I don't know. It just seems to me that the way it was done, it was making it very difficult for her to lay the foundation and give the judge the information about why a Frank's hearing should be had, when a lot of that information is sealed.
Right. And at any time, hell, in these other court hearings in the very beginning, you had Bill Thompson standing up there throwing his notepad saying, we can't have this information out there. It's sealed, Judge. So it's like, why isn't Bill Thompson standing up throwing his notebook down saying, Judge, you can't ask her that question because that information is going to get out to the public? I
don't know. It's a very, that's my thought about the hearing. It's very strange. It's a unique situation. I'm not sure where we're going with this, but with how they did it. But it's interesting when the judge is talking about the Pennsylvania arrest, and they had Jay Logston argue that. The judge had said something like, well, when they were following him around with a shotgun or whatever, he said, well, he played devil's advocate. He said, well, they were trying to, it was for officer safety and to prevent him from destroying evidence. It's like, okay, this is like a month and a half after the crime. What, like, he would have destroyed the evidence a long time ago. Right? I mean, I didn't understand that, but he was just, playing devil's advocate. But that's
just, it seems like a bunch of mind games. All right, so they're gonna, did you still want to play this one regarding the Frank's hearing and the warrants?
No, I think we know, what we're talking about.
Okay. I'm gonna go to the 1 hour and 2 minute, and that's the dog in the room with the door open. Now, when I first heard this, because we know Supposedly there was no blood on him. There was
The door was open.
no tracks. How it and there was, we had heard stories about how one of the neighbors said that they looked out and noticed that the door was open. So
They said it was closed, right? In the beginning.
who? No, I'm talking about no, in the very beginning there was a lot of stuff going around about how one of the neighbors had looked outside that particular morning and had noted that the door was open. The
Right.
sliding glass door was open on the second floor. So when it comes to like him being loose,
I don't know,
how does
I thought, if I remember correctly, I thought they said, and not speaking about the doors on the sliding door or the front door, I'm talking about when they found the puppy. They said he was in a room with the door closed. In Kaylee's room, he was locked in there. With the door.
Yeah, I've heard different things, but I heard that the door was open.
Oh. Well, I didn't know this about the door to Kaylee's room being open and the dog being in there.
Yeah, because no, we always thought, not the outside door. We always thought that the door that had Murphy, was Kaylee's old room. But in here, they said that the door was open.
Right.
So and then you mix that with what the neighbor was saying about how they looked out that morning and noticed it was odd that the door was open. Then how in the hell did Murphy not get anything on him? And this kind of adds, because remember, back then when there was discussion about the outside door being left open, there was also discussion about how Murphy wasn't at the house anymore. Also, remember there was a shelter being discussed and how Murphy was taken to a shelter.
I do remember that now.
And how Payne didn't know that there was a dog until he looked at somebody else's body cam.
Nunez's body cam.
So it's like maybe they didn't know what to do with the puppy, and they're the ones that turned it into the shelter. And we know our animals, when something bad happens to us, they're usually right there.
Yeah.
Next to us. And I wouldn't be surprised if Murphy had a whole bunch of stuff on him, because usually when you pass away and you have a pet there, they will usually stay next to you, right next to you. So it was one of these things where it's like, well, what?
It's very strange, but yeah. That's what I wanted to hear about that dog. That's the section.
Yeah, let me see here. 1:02, hour and 2 minutes. Let me see here. Let me get it. Almost, we'll go a couple seconds before that.
It's talked about this dog barking, and they key some time, and they say this is when something was happening inside this house. We can hear this dog barking, and they use the videotape to get a time off that surveillance tape from the neighborhood, the 1112 King. And so they've got this time.
So I know there's a lot of confusion as when it comes to the dog barking on the audio version of a video. The video that they're talking about is 1112, which is the same video that they're claiming that camera. It's a Ring camera that has the T section of King and Queen Road. No, this is 1112 Katrina. Linda Lane is in a different area. Let me let me bring up the map real quick. So if you guys remember there was the picture of the front porch, and we saw Xana and Kaylee and Bethany and all these people standing on that porch, remember? So this house right here, 1112, remember there's that porch, and then there's the video that has Queen and King Road, the intersection right here. So when they're talking about that audio, they're talking about because that's when there was something else they used the audio on 1112 before too. When the crime took place, not the dog, but when the crime took place, because there was other noises that took place as well. And so this camera right here, 1112, is the camera that they're referring to. Now, there's a Ring camera on the front door. Also, there's the camera that looks like a light bulb as well. But if you remember, I don't have the photo. I know Caddy might have it. If you have the photo of the porch, let me know, because that is actually the that's actually the screenshot where you can see they should have had a clear photo of the car front and back when it comes to this T section. Oh yeah, Katrina, you can definitely hear a dog barking on that camera, but when you're over here, no, you're going to hear dogs barking in all of these apartment buildings, because this area right here, just like when we deep dive Linda Lane, and by the way, we're going to have a combo deep dive I never got to from back in the day, and I totally forgot about it. Remember when we deep dove Linda Lane and we deep dove Grub Truck in the very beginning? I had always discussed that I had heard the same vehicles in the Grub Truck deep dive that I was hearing in the Linda Lane deep dive. And I said back then I was going to do a combo deep dive to track the movements of those different sounds when it came to the Grub Truck versus Linda Lane, because I wanted to see if these same vehicles were going from Grub Truck, Linda Lane, Grub Truck, Linda Lane, Grub Truck, Linda Lane, and I think they were. So I'm going to be having that coming up soon. But when we were doing that deep dive of the Linda Lane, this is why you could hear somebody else's TV show. There's all these different things, and then you got all of these different windows around here. What that sound is going to do is a lot of those sounds that you do hear on Linda Lane are coming from all of these apartments that live in this echo chamber bubble, because all of that sound's going to reflect off of all the different sides of these buildings, so it's going to magnify. Now, when it comes to the sound of 1122, when I went out there, I could test it, okay? I couldn't hear stuff over here. I wasn't hearing clapping, somebody clapping their hands and all this other stuff. I couldn't barely hear it. So to hear a dog barking and say that it's 1122, I would have to say that the dog is one of these neighborhood apartments, because you could hear somebody's TV show on that footage. And right here, yes, it does echo, but it keeps the sound waves of the echo in this area. If you're talking sound waves from here, most of those sound waves are going to bounce off of these structures and then go the complete opposite direction of Linda Lane. Only a small percentage of sound waves are going to go through, and then that wouldn't be strong enough to propel all the way over to the footage that came from right here. But yeah, she's talking about 1112, the dog barking. There's a lot of sounds. I mean, I remember in the very beginning, there's a lot of scary audio that was, you remember that, Yoli? All of that scary audio that was coming out, and, people screaming and fighting. And
You didn't,
really,
I mean, it was like, I don't know what's going on.
it really sounded like there was the crime going down, like the blood curdling screams and all of that stuff going on when because there was in the very beginning, there was a lot of audio.
You
If
have,
it,
I think.
yeah, if you haven't heard it, oh my gosh, look up 1112 audio. We're not saying it's real because nobody's ever been able to, to say it for sure. And there's been a lot of there was some channels that were kind of twisting it and making it out. They were even adding audio stuff on Linda Lane to support stuff going on, and it's like, no. But I'm telling you, when you listen to it, you're just gonna sit there and you're gonna be like, oh my gosh, I just listened to this thing go down. And I'm talking the sounds from the dog, the sounds from the people screaming, all the different sounds. Yeah, it's wild. It came out like, oh my gosh. Yeah, it got to a point where it got very manipulated. Yes, because people were like, the clickbait was just going wild after that. But yeah, when was that, Mishy girl? It was it had to be the spring of 23 when that stuff was coming out. Maybe February or March. Maybe even April of 23.
I think it was more like April, May, and then it went into the summer.
Well, because that's the summers when Linda Lane came out.
Oh, that's right.
Because we were deep diving the grub truck in December of 22. We were deep diving the grub truck already because we found out about the grub truck from Olivia. That's when we looked it up, and I think we were probably the first ones to deep dive it, honestly. And then we deep dived it again because the first time I deep dove it, I didn't want to listen to the audio because I can't stand the donations where it's like, hey, you could, they talk for you.
So weird.
They drove me nuts. And because I play games and I watch games and I can't stand it when I hear the automated voice because they say there's a lot of immature people in there and it just says some really stupid stuff. So a lot of the times I'll just mute it. That's why I muted it the first time. But then when I started to deep dive it again, and I'm like, oh my gosh, this is some code stuff being talked about. That's when we deep dove it again. Then I could have swore it was like the beginning of the year, maybe March, somewhere around there. There was a lot of 1112 audio coming out. And then a couple months later, that's when Linda Lane dropped. And yeah, because there was a lot of talk about the 1112 audio and the Jack in the Box at that time because people were using that picture from law enforcement, the picture of the Jack in the Box bag as the DoorDash. And that's when I was telling everybody, well, that's old because if you look at what's in the cup, it's already separated. It don't separate over 1 day period of time. It separates after a few days period of time. Yeah, that 1112 audio, it's creepy. It really is if you've never heard it yet. And I would look it up if I was you because with her talking about this, using the 1112 audio for the dog barks, yeah, it's going to pick up the dog barks. It's going to pick up birds chirping. It's going to pick up screen doors slamming. It's going to do all that. So yeah, it's going to pick up a dog barking for sure. All right, so let me play this again here, and you can hear it. 1 second. 102. Yeah, here we go.
It's talked about this dog barking, and they key some time, and they say this is when something was happening inside this house. We can hear this dog barking, and they use the videotape to get a time off that surveillance tape from the neighborhood, the 1112 King. And so they've got this time, but they also have this video, this trail that they've picked out a time that something probably happened here. And
Howard Bloom.
Don't tell the magistrate that this dog that's barking continues on long after the car they're interested in has left the area and then abruptly stops. Your Honor, the dog was found the next day inside the house in a bedroom with an open door, where the other bedrooms that contained people that died, their bedroom doors were open, and this dog had not tracked any blood around. The dog had no blood on it whatsoever, but it was just sitting in an open room.
How in the hell? That, I'm sorry. I'm sorry. Like, no matter how much, because we all heard stories from the beginning, Murphy was a party dog. There, you see all the times that law enforcement got sent over there for noise complaints. Most of the time, none of the people that lived in that house were even there. That dog had to be used to strangers like a dog has never been used to strangers before because of being in that atmosphere. What dog? All the rooms are, the doors are open, she says, which is weird because we heard from somebody that Ethan and Xana's door was wedged shut. So that makes me wonder if that's true. But if the dog has an open door, the victims have open doors, and they just happen to walk up and the dog's just chilling there.
That's weird. I don't know.
That don't wash.
And I didn't know about that, exactly that. And so it makes it, so far, everything that we've learned that is under seal seems to be, aside from the dog, but so far that what we've learned seems to be exculpatory to Brian. What we learned that's under seal. I mean, I don't know what else they have under seal, but the judge says something that makes me wonder.
I don't. It's. I don't even see Murphy sitting in there if the door was shut the whole time and an officer comes up and opens the door. I still don't see Murphy just sitting there.
It was, I don't know.
He had to be in a crate.
He did have a crate, but the crate was in Kaylee's car, I thought. I don't know.
It's
really hard to not misstate something in this case because, it's hard to not misstate something in this case because so many things happened and it's hard to remember. And sometimes we remember it a certain way and it wasn't that way. But I remember, I think Kaylee's mom said the crate was still in her car. So
I don't see. I mean, if the dog was there and it sounded like somebody was playing with the dog. And the next thing you know, I heard noises upstairs. The dog. The dog would be running in there to save Mama. Like, I mean, look at how much you could see the videos of Kaylee and Murphy. You're not going to tell me Murphy wouldn't have tried to save Mama. Give me a break. There was so much love between them two. My baby angel, I can't go anywhere without her having to make sure that she's right there keeping me protected. Even if I'm going down to get a drink, that girl's got to get up, even if she's in a dead sleep. That girl's got to get up and she has to come down with me to make sure that everything's fine. And then I come back up and she comes right back up and then she goes right back to sleep. These pets love you. They want to protect you. I don't, the dog just chilling there. And all of the all of the smells. I mean, think of our noses already. And then you're talking about a dog's nose and
Yeah.
all the extra scents that they pick up and those kind of smells. You're going to tell me the dog? I just don't.
There was something so strange about the dog. Now that I've heard this whole thing, and it kind of, I'm confused. I'm actually confused, but I mean, I don't know.
Yeah, I remember that too, Misha Girl. The story that he got out and was loose. I just, yeah, right. And was there a leash? There had, I don't, there, it had to be. I just don't, I don't even think they would have put him on a leash, honestly, because I really feel like they, what I think is, it's like what I do when I would travel with baby. I'd have her kennel cage with me, and then we would go somewhere, and she gets to play around and do all this stuff, and then the kennel's right there, so she needs to go to the bathroom, she can go to the bathroom. If I needed to take a shower and I didn't want her to mess up, a room that I was staying in or something, or a house or whatever, I'm gonna shut the door and leave the kennel in there. I'm not gonna leave her in the kennel. I'm gonna leave the kennel in there and leave her in the room for whatever period, take a shower, whatever. I would see that that's what she would have done. I don't see her putting him on a leash inside of a room. I don't see her leaving him in a kennel inside the room. I don't see her like, I mean, this is a dog that got to roam around the whole house as it was already. That's one of the reasons why you see in some of the roommates videos on social media that they got a little annoyed about it because they were having to clean this or clean that or the barking or whatever. So I don't even see why anybody would secure it to a certain area where it wouldn't have been able to run free unless a door was shut. So any of this stuff right here about the dog, none of it makes sense whatsoever. None of it. The fact that the door was left open, the fact that there was no blood on him, the fact that he wasn't even barking anymore after the car left and there was no more barking.
It's weird. And that's why she's bringing it up, because it just doesn't sound right.
It sounds like he was barking, the door was left open, and he did escape. That's why you didn't hear the dog anymore. The dog was barking for an extended period of time after the car left. Probably because it was probably saying, Mom, 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 Mom. And then after that, probably I need to save. And then they're going to go roam and try it, just like OJ's, remember? Nicole's dog. It was barking so much it alarmed the neighbors, and then it eventually left and went and tried to find a neighbor.
Yes.
Same thing. And so I can see how the dog and barking, and then you don't hear it anymore. It's the same kind of story with the dog for OJ. So let me see here. So this one right here, no connection. This is 1 hour, 20-minute timestamp. No connection to victim's crime scene other than touch DNA on the sheath. All right, so we'll let this play out.
And that's not true. This court can rely on our proffer in D1B and in the cast draft report and in the cast final report, because those dates change. The court can rely on the evidence that will be produced at a hearing from defense experts that will talk about the handoffs, the patterns of handoffs, and how misleading that paragraph was to the magistrate. The real story is exculpatory to Mr. Koberger. He was not stationary around that house. He was never at that house. He did go to Moscow. He did drive around. but he wasn't over there. And the phone records absolutely show that. We'll move forward to the set of warrants that come a little bit later in February, March, April. I'm talking about Amazon, Google, Apple, those kinds of warrants that come later. Here's what is left out of all of those warrants. The fact that Mr. Koberger gets arrested, his apartment gets searched, his car gets searched, his car gets searched again, and his car gets searched again, and there's absolutely no connection between him and anybody from 1122 King. And what I mean by that is that there's no blood in his car. There's no he wasn't connected to that house, to the people in the house.
Why'd she just not finish the DNA part? What was that about?
Well, I don't know, but I have a feeling it's something related to it being sealed, because look at the judge. The judge is like, are you going to go there? He's like, I don't know. But that's the problem with this hearing, is that so she's basically saying that the warrants for the electronic stuff, that there was no in other words, what they left out of the affidavits that they're supposed to give the magistrate to get the warrants for the electronic stuff, what was not in there was that there was no connection found between the car, his apartment, and whatever else to the victims. But then the defense comes back and says, but wait a minute, we didn't have that information of the car yet when some of those warrants were
right. They did. Yeah, they did.
So there's an argument there, but the fact that she stopped right there, and I think she stopped because maybe there is DNA in the car.
Yeah, that's what I thought when she stopped. Like, whoops, I meant to say IGG.
Or
like,
well, she stopped because I think the judge, because he told her, like, I'm not sure why she stopped, honestly. She stopped, but then later she says it.
Well, it's weird. She stops in the middle. You would think if you didn't need to, you would just, like, DNA, like, oh, I already said it. It's not going to hurt me. I'm just going to DNA. And then she stops and then goes on to something else. It's like, whoa.
I thought it was a video glitch too, Miss Your Girl.
Was it?
I thought it was, but it isn't. And maybe there was DNA from Brian Koberger in the car, which you would expect.
That's right. Maybe that's why she said that.
I'm not sure. It's weird.
Let me look. I'm going to play it one more time here.
And what I mean by that is that there's no blood in his car. There's no DNA.
No, she stopped.
He's saying something to her.
She stopped.
The judge is saying something to her. Look at the judge. Don't look at her. Look at the judge.
Let me see. 121. Okay, let me go back to this. That's why she stopped, because he gave her that look, huh?
Well, he was saying something.
And what I mean by that is that there's no blood in his car. There's no DNA.
Oh, he did say something. It got muted. He did say something and it got muted. Watch. That's why she stopped, because as soon as she starts to say D, you can see his mouth go blah 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 blah, but you ain't hearing him saying nothing.
And what I mean by that is that there's no.
Here, let me zoom in and I'll get rid of this so you can see it. Hold on. Let me zoom it in for you. All right, that's his 21, 32.
And what I mean by that is that there's no blood in his car. There's no DNA.
He said something right as she says, and there's no, as soon as she said there's no blood in the car, he starts saying something. It was before she even 121. Watch, he starts saying it as after she just got done talking about the blood.
And what I mean by that is that there's no blood in his car. There's no.
Right there, he starts to say it. When she says there's no, before she even gets to DNA, he's blah, 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 blah. Damn, they got some good, man, they got some good editors, or it must be on a delay or something. Because how do you.
It.
Yeah. Yeah, so he actually stopped her before she even said DNA. And then he's still talking as she says it.
Maybe he was going to say, maybe he said something like, well, that's not disputed. Meaning that the defense.
So she didn't have to say DNA?
I have no idea. I'm speculating on what he said because I can't tell.
Yeah, all right, hold on. We'll go back. Let me see. What did I have it on?
Yes.
There we go.
Everybody is saying, oh my God, why did she stop? Why did she stop? Well, look at the judge.
Yeah, she didn't have to finish it, I guess, after what she just said. All right, here we go.
And what I mean by that is that there's no blood in his car. There's no he wasn't connected to that house, to the people in the house. Your Honor, I'm
Maybe I mistake me thinking of a different date for the AT&T. I thought not the cell tower stuff. So you're still talking about the cell tower stuff?
No, I mean, that stuff applies to every single warrant we have because that was early.
I thought you transitioned to warrants that were obtained after the arrest.
I did.
Yeah, and by the time of the arrest, they had a direct DNA connection.
Your Honor, what I'm talking about.
Some other evidence that the defense can claim in cross-examination or their own case is exculpatory, but isn't the DNA connection in itself probable cause to support any of it from there?
Your Honor, the DNA I'm talking about is the lack of DNA in Mr. Koberger's car and the lack of DNA in his apartment, the lack of connection to the individuals.
What is that? Even if disclosed, preclude a finding of probable cause when there's a DNA match between the DNA in the sheath and Mr. Koberger.
Here, pause it for a second. So you know what I didn't hear from this in this hearing that I thought I would is the fruit of the poisonous tree. In other words, they would have never, assuming Brian wouldn't have consented to give his DNA. I mean, I don't know, maybe he would have. We don't know that because we don't know if the police talked to him and asked them for a DNA sample. But what is missing from here is the fruit of the poisonous tree is that they would have never gotten to him and they arrested him in such an intimidating manner that, I mean, the guy was probably scared shitless.
Yeah, I can imagine.
Excuse my language, but the
whole family.
They're
lucky somebody didn't have a health issue from it.
Or they're lucky that somebody didn't react and go into some kind of fight or flight mode and started to fight. I mean, the way they did it was so intimidating that he did give his DNA sample. But think about the circumstances that he was under.
Wow. Can you imagine that if that situation would have took place? It's almost like maybe some people might want that.
I don't know, but
you create a drastic enough situation where somebody just defends themselves like that, and somebody gets, taken out before trial, or,
Oh yeah, it's really crazy because I think about that and I think, I just think that how the whole circumstances, he gave his DNA, but what led them to do this arrest was the match between the father's DNA in the trash to the DNA on the sheath. So the IGG is what led them to the father. So it's fruit of the poisonous tree if the IGG is kept out. And if because without the IGG, I mean, what really do they have? I mean,
you wouldn't have had the SWAT operation.
Well, I don't know what's under seal, and I have to say honestly, so far what's leaked is exculpatory. What we know, what's been leaked in these hearings, because you have to argue the facts, it's been leaked. It's exculpatory to Brian, but the judge mentioned something when they're arguing the arrest of Brian, the way it was done, and it led me to think, what the hell? I don't know what to think. This is just intriguing. And I didn't see that the judge was talking to her. That's why she stopped.
Yeah, I didn't notice it either. I thought she stopped herself. And then when we went back, and I wanted to see exactly when he was saying something. And then that's when I noticed, whoa, he's saying something before she even said DNA. So, yeah, it's, and I think they were Moto. You know what I'm saying? It doesn't that it's not like it would be the first time that took place, right? Somebody gets taken out before a trial, you know? Yeah.
Yeah, the entire family was held at gunpoint, and
Yeah. I can't imagine. The sister, him, mom, and dad. Can you imagine 3 a.m, all of a sudden? Oh man, I can't imagine. Yeah. Payne had the wrong email. We'll be getting to that. Trust me. We'll be getting to that in Sunday's show. That'll be a good one too. We're almost done with this court hearing here, and then on Sunday we'll do the court hearing that was on 124, and that one's going to be off the damn chain because there's a lot to discuss about that one, especially the testimonies and stuff. Let me see here. So I'll let this one play. This is still no connection to victim's crime scene other than touch DNA on the sheath.
Isn't that probable cause every day and twice on Sunday?
Not in this context. Not in this context, because of the IGG work, because
of the intimidation tactics.
That's the ultimate question.
Pause it for a minute. Because of the intimidation tactics that they used to get his DNA in a buccal swab. I mean, they basically went in there, threatened his whole family with a SWAT team, and said, "You're going to give us your swab." Okay. That's why.
Mm-hmm.
Oh my God.
Ain't it crazy when they could have just said, "Hey, can you come down here so we can take a swab?" I mean, really.
They may have done that. I don't know, but
can you come down to the station? Yeah, can we take it? All of this stuff is just, when do you hear it going down like this? Whether it's Murphy or the SWAT operation or the connection, I mean, all of it. When do you hear of any of this stuff happening this way?
I mean, look at I always say the Lisk serial unaliver, peaceful arrest out in front of a store.
Yeah.
Men in suits just come and handcuff.
Yeah, and think about all the amount of people he, committed crimes against, and this supposedly is just one person that did 4.
It doesn't make sense. Even with the guy that the one guy with the bushy eyebrows that unalived the CEO, they went there to the McDonald's, and there's no SWAT team or some huge. They didn't follow him to where he was staying and do this whole operation. And I mean, I just there's something not right, and I can't put my finger on it, but I still have to say we don't know what's sealed, because my fear is, at trial there might be something that's like, whoa, we
Right.
didn't know that.
Well, just like the stuff that we learned, in these two, we didn't know a lot of this stuff that has come out. These two hearings were probably some of the most revealing, I would say, out of all of them. I've watched them all from the beginning. There's been a couple where it was like, holy hell, it was crazy, the information that we were getting. But these two right here, it says so much about what this trial is potentially going to look like. The stuff that's going to be argued, what is there, what's not, the don't recalls and all this other stuff. It's like, okay, this usually happens this way. These people usually know these answers. Like, you would think if you're a lead and you're part of a prosecution and you're trying to make sure you want justice for these victims, you would come prepared. You would read your notes. You would know what you're going to say before the question's even asked, and you're going to know what you're going to say to stuff that's not even going to be asked, because it's not about you, it's about these victims. And so I just find it all hard to believe that this is the approach when it comes to making sure that the victims truly get justice. Very revealing to me. Let me see here. So they're going to keep discussing this here. And then after this, we'll switch to a new police report. And then we will come back on Sunday for the next episode. And that one's going to be spicy.
Question that will be before a jury. What does that mean, right? What does a knife sheath at a scene mean? That's going to be the ultimate question.
Killed by a knife, it probably means a lot.
It might mean a lot.
Probable cause is not a proof beyond a reasonable doubt standard. It's probable cause to think that this person might have done it. And I'm not sure how that direct DNA connection to a sheath found on or near one of the victims doesn't close the book on anything on probable cause after that.
Well, I think it doesn't close the door on probable cause. I think when you know the other factual information that the magistrate should have known, I think that there's a lot of pause even at a probable cause level, Judge. This was information withheld from the magistrate, and I'm talking about, let's just go with the car. Let's just go with.
I understand the lack of evidence of DNA material or other victim-related material in the car and in his apartment, as asserted, but I'm not sure how that precludes probable cause when there's a direct DNA match. There's plenty of reasons that might be the case. When a magistrate's looking at this, they have a direct DNA match to a person from a object likely associated with a murder weapon. I've not yet a magistrate would not find that probable cause.
If the magistrate had the other facts, I think the magistrate would have some serious concerns and would not find probable cause. Your Honor, the vehicle, and I know the court knows what I'm going to say. There's not DNA in that vehicle that was brought out from a crime scene. This absolutely matters, Your Honor. If you want to go to the state's theory, right, with their videos that they've talked about, they told the magistrate about that this is the video, this is what matters. It parks at this certain time, it leaves at this certain time. If you want to go to that, there's about 13 minutes of time, right? 13 minutes between the last time you see the car and the next time you see the car on the video. And if you end up with a car that's searched, and I mean searched and taken apart, the brake is taken apart, the gear shift is taken apart, the key fob is checked. There's no blood on any of that, none. The steering wheel, there's some kind of spray all over the interior of the car to check for it. There's no blood. I think that there's context that the magistrate should have known that's absolutely exculpatory to Mr. Koberger, and it matters a whole lot.
I'm not saying it's not potentially exculpatory. I'm just saying I'm not sure how knowing that in light of a positive DNA connection would cause any magistrate to say, well, okay, I guess there's no probable cause here because you couldn't find other connection to forensic evidence. When there are other things in the affidavit or affidavits at that point that could explain that, including the use of covering clothing and covering gloves and all that could be put into a bag real quick on the way out that was in one of the affidavits. I guess, and I don't intend to argue with you about it. I understand your other arguments, but when you get to once they have the actual DNA, evidentiary DNA, it seems to me that it's an uphill battle to say there's not probable cause at that point.
Well, Your Honor should never get to that question, but I'm going to answer it for you. But you should never get to that question because you should have already found that AT&T 1 and AT&T 2 were terrible, and there's no probable cause for those, and they just build on each other. So you should find that the very first one lacked probable cause, and then everything else does as well. But let me answer your question there. If the magistrate judge had been told there's unknown male B in blood in the house attached to the handrail, that might have made more of a difference to her. Maybe a sheath that can be carried to the house and blood in the house that's not the same, maybe that matters. And then maybe the car being completely empty of any blood DNA connection, maybe that matters a little bit more.
Well, I'm just not sure why it matters for probable cause, but I think we're talking over each other, so I'll let you just go on.
Okay.
So why interrupt her?
I don't think probable cause is in a vacuum. I think probable cause isn't one thing. I hope it's not one thing. I hope there has to be a little bit more than one thing, especially when you've got another thing that's the same as the one thing.
Well, I said I wouldn't do this, but I'm going to do it anyway because you brought up blood DNA of an unknown individual that was found, I think, on the handrail.
Yes.
Doesn't that necessarily not exclude Mr. Koberg? What it may do is suggest there might be a potential other person in addition involved if you assume that blood was related to the victims and not some earlier event in the house.
What?
If what the court is saying is exactly why the magistrate needed to know that. Is there another explanation here? I've got this sheath, but there are all these other things that if I know about them, matter. What's the other explanation? What's going on with this investigation? What's happening here? That's exactly the point, Your Honor. What other explanation is there? The magistrate wasn't given a chance to ask that. She wasn't given a chance to ask that when she wasn't told about unknown male B, blood on the handrail. She wasn't given a chance to ask about that when she wasn't told about unknown male D, blood on a glove right outside the residence. She wasn't given a chance to ask any of those questions. She didn't know that Brian's car and the court's question, good question.
That's pretty bad when somebody doing a YouTube video finds the glove. No, I mean, it's Chris McDonough who found it. He's an old, but still, you're retired. You're in a YouTube.
But why didn't they canvass the area? I mean, was it, see, that leads it to
they didn't.
That leads it to the suspect though, because they're saying, okay, somebody else found it. How do we know it wasn't planted there? After the fact, after they looked at everything, you know what I mean? And it just muddies the water, but it just shows that there's reasonable doubt. I mean,
well, this is the crazy part when it comes to that search. When it came to the search of 1122's property when they were there that day, do you know where they cut off their search at?
It was very limited.
It was here, let me Go ahead. I'm gonna bring up a Google Earth to show everybody where that search line was located.
I'm
Uh-oh. Hello?
Oh, I said I was going to take a little break.
Oh,
I'll be right back.
yeah.
While you pull up the area that they did the search.
Okay. Let me see here. 1 second. I'm going to show you guys the search line. You're going to lose your... All right. So here's 1122. Okay. So I'm going to show you where they had the search line. This is Queen Road apartment. Oh, hold on. It's not sharing it. This is Queen Road apartment. All right. Queen Road apartment. This is where they had it taped off and where they were searching. So when you look at this right here, this is the area that they were searching. They didn't have any searches taking place over here. Nothing taking place back here. These backyards weren't searched. The trees behind the parking lot weren't searched. This is the area that they focused on. Now, when you don't know how somebody left the scene and you're trying to search as many areas as you can because you don't even have a weapon, who's to say somebody didn't toss the weapon in one of these trees? It's crazy to think when you look at how much there's so many other places. When I was there, I came up with a route that the person would have been able to commit the crime if they didn't live in this area as well. Not just all that. So say they committed the crime and they come out here because nobody's going to notice you, right? You could literally walk up here, go through this yard, sneak through these trees, and be on your damn way going somewhere else, and nobody would have even noticed you until you got on the street right there. So the fact that this area was only searched, this was the line, Yolie. That was the line. So let me connect them so it fills it in. Oh. So that was the line where it got cut off. They did not search anywhere back here whatsoever. They didn't search anywhere back here, and that's...
And I'll never understand when those people, they were like not in law enforcement uniform, but they went and they pulled the jacket of Maddie. Well, I don't know if it was Maddie's jacket. I take it back. But they pulled a black jacket that was near the fire hydrant. And it looked like they took something out of the pocket of it, and then they just threw it back.
Mm-hmm. Yeah, they didn't even... it looked like they were checking to see what was in there. It's kind of crazy. In one of the interviews, and I'll have to find it. One of the interviews, Christy G talks about that black jacket. I think I made a video about it actually in my video section. If you maybe look up my name in the search bar and then look up Maddie's jacket. I know I did a short video on it, and I know I watched the interview with Christy and Steve when they were talking about it. Yeah, you're right, Caddy. Excuse me. She said the girl shared the black jacket.
Something like that, I remember. And I'm thinking, why would they do that? Like, I don't understand. If maybe they weren't law enforcement, but as far as I thought they were. I don't know.
It looked like them.
I have
It
no
looked like
idea.
them. Yeah, it definitely looked like them. Let me see here. Let me go back to this. So let me see the last thing. Is there anything more you want to discuss about the no connection to the?
No.
Okay. All right. So this will be the last timestamp for tonight, and then on Sunday, I already got the notification out there. If you want to go click on it now, you can have the notification when we do it. Same time on Sunday. It'll be the next court hearing. So this is 2:13 to 2 hours and 14. New police report. Okay, so 2:13:30. And thank you for the timestamps, Yolie.
No problem.
Let's see. I'll have to go to 18.
Well, briefly.
I'll try.
I'll try to do my part to make you so that you can and avoid asking questions. I'll say I'm truly stumped.
Before I get started on what I want to tell you, and in response to what the state said and then my summary, I'm curious about the new police report that was talked about. I didn't see it in the submission given to your honor.
I've had such an avalanche, I can't think of what it is off my head. If it did, it certainly wouldn't be part of the analysis for the court in determining whether or not you've met your showing to have a Frank's hearing.
Well, that's good because it occurred after my Frank's briefing came. So I didn't get a chance to respond to that yet. All right.
So there's a new police
with
report. A new police report that was handed over to the judge, but it appears not to her. What is this? A new police report? That's weird. You're on mute, CJ.
Freaking. So maybe they noticed. Oh shoot, we forgot to include this in the discovery or something. Like
It was
what?
only given to the judge, though. If you heard, she said, I haven't seen it, but I heard they were discussing it, and it was a new police report. I don't know.
I don't either. It's weird.
It's weird because I don't know.
It's so confusing when it shouldn't even be.
Right.
You know. There's that link, you guys, if you want to see it. I know I was going through the interview on that one. So I'm going to have to take a look at it myself to remember what interview they said it on so I can bring it up in the future if I need to. But I want to say thank you so much. I can't wait until Sunday when we go through the next one because, you know, especially with the testimonies and stuff like that. So, you know, if you know, come anybody watching or if you're on replay, take some notes, links out there, come back on the episode of Sunday and we'll go through them together as well. And then, like I said, I'm gonna be doing some picking up my shows again, where we were discussing Enon and Emma and Demetrius and some of those other characters. There's a lot of stuff that I never that I had planned on doing, but then we ended up going out to search for Riley at that certain point, and then it was Sebastian and Micah and just constant travel. So I'm going to be here for another week, 2 weeks or so. And so as we're discussing these, I'm starting to remember, oh yeah, I needed to do this and I needed to do this from back then. But one of the things I'm going to be definitely starting up is doing the combo deep dive that I never got to from 23, 2 years almost. Going through the Linda Lane and the Grub Truck not the deep dives of each individual one, but back then, because we do have our deep dives, you can look them up. They're in their previous lives. We do have the deep dives for those if you want to watch them. They're old as hell, so don't make fun of me because there's a lot of changes that have gone on with the production of the show since then. It was real freaking basic back then, but I'm gonna be doing the combo where I'm gonna try and because I really feel like the stuff that happened at Grub Truck ever since we went into the Grub Truck, I felt like not only the cast of characters that were on the video, but also the cast of characters of mufflers that you could hear going through. Because when we did that deep dive and then we started doing the Linda Lane deep dive in the summer of 23, that's when I was like, holy hell, I've heard these mufflers so many times because we already did 2 deep dives on Grub Truck. So
Yeah, that was.
yeah, I'm gonna figure it out. Like I said back then, I'm gonna have it mapped because I really feel like they were going back from the Grub Truck to the house, Grub Truck to the house. Like there was people watching these girls. I really feel like so.
All right.
Thank you all so much. Appreciate you. Have a good night. Peaceful,
Okay.
positive evening.
Good night.
And we'll see you on the next one. Thank you all. Appreciate
Okay.
you.
Bye-bye.
Thank you all.
Okay over there? Alright, is your victim at the hospital? Someone shot there. Alright, the ET doesn't take pictures of the boat. Is it domestic related? She's calling back. We're going to try to give her a call again, and then she just added another phone number to the 13-year-old grandson, who's possibly with the daughter. Seven with that.
2412.
Someone's calling in to give us email that are suffering. Detective 12, take the check that one out.
Take one more, 567.
Also still saying stuck. No. Okay, there's that Steve. Simple with it. If anyone else involved with this, let me know. That's fine. 33.
Supervisor not station court attached.
Yeah, possible here in a moment.
First time out. 10-4.